Hi guys! Hope everybody is doing well today. So we are going to be looking at an exoneration story involving actual innocence. This is in Texas, so we're going to look at a relevant statute and we're going to talk about some of the case law in Texas. This decision's coming down from the Texas Court of Criminal Appeals. They break up their Supreme Court into a civil and criminal branch. So what we're speaking of today is essentially the Supreme Court, the highest court in Texas for criminal matters. They are clearing Travis Cobb's name. 6 years ago, he was convicted of stabbing a loss prevention worker at a Walmart. Really based on this video surveillance you see in the preview image here. We're going to get to the story and what was wrong with this and why he's actually innocent. And then we're going to get to, we saw the thumbnail said squabble. And SteffJK showed up right away because of the word squabble, I think, in the opinions, right? So we get this writ of habeas. Hey, I'm actually innocent. You shouldn't be holding me in custody. Here's why. The court agrees. The court agrees that Travis Cobb, we shouldn't be holding him. Reverse the conviction. But the justices get into a squabble about the actual innocence standard that Texas has. And one of the judges in particular, really like in a scathing way, 22 pages in his concurring opinion, just goes after the opinion of his colleague. So we're going to look at those. We're going to look at the squabbling arguments. And really, to me, from what I saw of the first few pages before I decided to go live, one justice is telling the other justice, bro, like, why are you even doing this? This is stupid. So we're going to look at that. It's going to be great. We'll start with a top level, the news coverage of Travis Cobb's exoneration. So let's check out this quick release.
Let's talk about credibility.
Oh, we got an ad.
I'm Dr. Brett Osborne, a board-certified neurosurgeon.
Oh my God, it's 30 seconds? Okay,
Friends,
here we go.
new at 5 o'clock, Travis Cobb spent years in prison for a crime that he didn't commit.
In a rare move, the Texas Court of Criminal Appeals last month declared him innocent. But as News 4 San Antonio's Mariah Medina explains, justice comes with a twist.
A resemblance to a still photo from Walmart surveillance video showing the back.
Now let's pause here. I get that the guy has like no hair going on. Maybe that's similar. But is this a high quality piece of footage to identify someone with?
Back of a suspect's head in this 2017 robbery. That's
The back of his head could look like me.
what first led investigators to zero in on Travis Cobb.
Unbelievable,
A Park police officer testified he recognized Cobb in the video and knew Cobb had worn a boot, like the suspect in the video. Except, as court records show, the officer failed to mention it had been years since he'd seen Cobb. Nevertheless, a jury convicted Cobb of aggravated robbery and sentenced him to 25 years in prison, serving 6 years of that sentence for a crime that recently tested evidence showed he didn't commit.
Were you hopeful that the criminal justice system would work itself out?
Yes, yeah. I really was.
Though he wasn't sure how or how long. That is until his parents hired appellate attorney Dana Jones.
Now, pay attention. We're going to get into the details of, the facts of the case, what didn't come in at court. It's going to be discussed in the article a little bit, as well as in the longer concurring opinion. But pay attention to this. We see this zoom in, and I like what the editors of this video did with the news agency. They zoom in on that chill out cup that was in the surveillance video that the guy was walking around with.
To be able to prove actual innocence is pretty rare. It's not something that happens very often at all because it is so difficult. It is a really high hurdle that defendants have to be able to prove.
But Jones and her team were able to do just that with the help of the Bexar County District Attorney's Office's Conviction Integrity Unit. After Jones discovered a cup used by the perpetrator that had never been tested until recent years. Results of that testing, along with follow-up interviews proving something Cobb knew all along. He was innocent. However, the true perpetrator can never be held accountable for the Walmart robbery because the statute of limitations has expired. He's currently serving a sentence for an unrelated crime. Though despite losing years of his freedom, resentment is something that is far from Cobb's mind.
Really don't even, so I just can't even think about it really, And I'm not gonna let anything there, like upset my life. I'm not gonna be, that would interfere with my life,
Mariah Medina, News 4, San Antonio.
So there we go. That's the top level summary. We heard a little bit from Travis Cobb there. They have this cup. They don't test this cup. When we're in the appeal stage, post-conviction, parents hire an appellate attorney, so they're scrounging up their money to be able to afford an appeals attorney. They say, hey, can we test that cup? So, and thankfully, the post-conviction unit here in Bexar County, Texas, they don't fight this. So they test the cup, and the DNA does not match Travis Cobb. So it's to me, it's a question of DNA testing. I don't know the dollar price tag on DNA testing, but I can confidently guess that it's negligible compared to spending 6 years wrongfully in custody. So that's the top level summary. There's some quotes in this article, a little bit more on the facts here. So we'll breeze through this, and then we'll start looking at the justices, the judges. They're concurring and little squabbles with each other over actual innocence and the bar that an appellant needs to reach that standard of an actual innocence declaration. So this is actually saying San Antonio. I think it was Mixed Chick looking for the city. So San Antonio here. A man convicted in the robbery and stabbing of a Walmart loss prevention officer was declared innocent by the Texas Court of Criminal Appeals late last month, nearly 6 years after a Bexar County jury wrongfully convicted him and sentenced him to 25 years in prison for a crime he didn't commit. And now, I get that this is technically written correctly, and juries do, in my opinion, juries can get things wrong. Juries can be a little funny sometimes. But here it's worded like it's the jury's fault, but seems like the evidence presented to them, they didn't get to know about this DNA on the cup. So, zooming back there a little bit. It was a grainy surveillance video depicting the back of the suspect's head that caused investigators to zero in on Travis Cobb. Unbelievable, this is Cobb speaking, reflecting on the investigatory shortfalls that led to his conviction. According to court records, a San Antonio Park police officer testified that he recognized Cobb in the surveillance video, and he noted that Cobb had worn a boot similar to the suspect's. Now, we heard this, and this is huge. However, the officer failed to mention that he had not seen Cobb for years prior to the identification. Now, I don't know if anyone in the chat has ever worn like a hard casing style cast, like a boot. But typically a physical therapist, your physician, your treating physician, your surgeon, the goal is to get you out of that hard casting sooner rather than later. So I don't know how severe whatever Cobb's injury may have been. Don't even know if it was the same foot. This officer just says, yeah, at one point in time, Cobb once wore a boot. But this is years later and you haven't seen him in years. I don't know of anyone that's had an injury where they were wearing a boot for multiple years. They try to get you out of that. And then the jury doesn't get to know that. So the jury wrongfully convicts him, but they don't know this detail. They hear police officer in uniform, who are probably inclined to trust, says that he identified this person and knows that he wore a boot. Okay, that seems to check some big boxes. Well, not when you think about it in the context of it's been years since I've seen them. Nevertheless, Cobb was convicted despite testimony from those who knew him, including a caseworker with the Department of Veteran Affairs, who said they had never seen Cobb wearing a boot around the time of the offense, and despite the officer erroneously characterizing Cobb as homeless. What? What? Oh my gosh. How does that happen? Don't they have, like, his address and information? Asked if he remained hopeful the criminal justice system would eventually correct the mistake, Cobb said yes, though he wasn't sure how or how long it would take. Cobb's exoneration came after his parents hired appellate attorney Dana Jones. So shout out to Dana Jones. I think Honorable Yeah That was on that already earlier in the chat. Where was Honorable Yeah That? We'll get that up on the screen. Okay, I swear I saw something from someone shouting out Dana Jones. There we go. There we go. We'll get that on the screen. Jones and her team discovered a cup from which the actual perpetrator drank, because he's seen in the surveillance that was reviewed by the police officers and the district attorney's office. He's in there drinking out of this cup. And guess what? The cup was collected in evidence, so they had this thing that they saw him using. The actual perpetrator. But they never tested it until Jones's request. Yeah. The results, along with follow-up interviews conducted by private investigators, confirmed something Cobb had known all along. He was innocent. So, we have a quote here from the appellate attorney, Dana Jones. The DNA came back as mixture DNA. One of the DNA profiles was identified as a female. She was identified in CODIS. So, that's their database where they have matches. And that female had been stopped at the scene that same day. She was walking in with the suspect. She said, I don't know who that is. I don't know who you're talking about. I was, walking in with a bunch of people trying to bum a cigarette, I think is what she said. So when her name came as the DNA on that cup, I told my investigators, you need to find her and talk to her. Jones investigators began visiting addresses associated with the female until a person at one of those addresses told investigators they not only knew the female, but knew the name of the man who'd actually committed the crime. So do you see how simple this is? Now, these officers in the initial investigation, they're tunnel visioned on Travis Cobb. But when they're doing this years later, they don't have a name in mind already about this person where they're talking to this woman at the house that opens the door and says she knows the female that was identified in CODIS. They don't have a name in mind. They're not steering this person who's answering the door to say, hey, it was this guy instead, right? This person's volunteering a name. They just know years later. So do you think this same person could have known this information 6 years earlier if they looked at this cup and tested it for DNA, this cup that they've had for all 6 years? It's like this person's like, oh yeah, I know who did it. Neon flashing signs. The true perpetrator was being held at the Bexar County Jail on unrelated charges. Jones went before a judge to request that the man's DNA be collected, and the judge authorized the request. Look how easy that is. Something Jones said likely wouldn't have been possible without the support of Bexar County District Attorney's Conviction Integrity Unit. To be able to prove actual innocence is pretty rare, Jones said. It's not something that happens very often at all, because it is really a really high hurdle that defendants have to be able to prove. Although the true perpetrator cannot be prosecuted for the Walmart robbery and stabbing due to the expiration of the statute of limitations, he's currently serving a sentence for an unrelated crime, the DA's office confirmed Monday. So, imagine being the district attorney, and you love to brag about convictions, and now you've got to come out and say you can't actually convict the right person anymore because it's too late, because you didn't test the evidence you had. And then you go, well, but at least he's doing a sentence for something else. And we're not specifying, if I really wanted this to be a big deal, I'd be like, he's doing a long sentence. It wouldn't even make a difference. He could be doing a short sentence. And I believe I saw somewhere that it was mentioned this other guy was actually in jail, suggesting it was a shorter, a less than 1 year sentence. So I don't know. As for Cobb, despite losing years of his freedom, they go through this resentment quote where he says, I can't even think about it really. I'm not going to let anything up there upset my life or that would interfere with my life. And now this is a statement about the Conviction Integrity Unit. So again, shout out to the Conviction Integrity Unit because they said, yeah, go ahead. We're not going to oppose your motion requesting to test this cup for DNA or request the DNA of the perpetrator that you found when you spoke to one person that we could have spoken 2 years ago. So Bexar County District Attorney Joe Gonzalez said his office will have a formal ceremony recognizing Cobb's innocence and release the following statement regarding Cobb's case. I want to commend the outstanding work of our Conviction Integrity Unit. for their dedication and leadership in pursuing justice in Travis Cobb's exoneration. The unit was established to ensure that cases like Mr. Cobb's are thoroughly reviewed and that any injustices are brought to light and handled appropriately. While we can't undo the past, I hope this resolution provides Mr. Cobb and his family healing and peace as he begins his new chapter in his life. San Antonio Police Department did not return a request for comment, and I think that is it. So there is the top level rundown of how we got here and what's happening right now. Just crazy. Just a lot of it is crazy. So if we get into the nitty gritty on these opinions, we're going to be talking a lot about actual innocence. So I thought it'd be good to look at a quick statute. In Texas specifically, and different states recognize this in different ways. Some states have established, different thresholds for monetary financial compensation when there's a finding of actual innocence compared to just like some other relief, post-conviction relief, where maybe your sentence is vacated, but there wasn't a finding of actual innocence. Here, specific to Texas, a finding of actual innocence, you could get your pardon. Everything should be expunged. It'll be like it never happened except for the 6 years that you lost. So they've got in Article 55A, Section 3, pardon for actual innocence. A person to whom this subchapter applies is entitled to have all records and files relating to the arrest expunged if, 1, the person is A, tried for and convicted of the offense for which the person was arrested, and B, subsequently pardoned or otherwise granted relief on the basis of actual innocence with respect to that offense. So here in this situation, the Texas Court of Criminal Appeals granted him relief on the basis of actual innocence. So he meets this category. And 2, the applicable pardon or court order clearly indicates on its face that the pardon or order was granted or issued on the basis of the person's actual innocence. So we're there for that for Travis Cobb. This isn't an easy thing to get a court to declare. And then here from the Post-Conviction Integrity Unit, they've got, they've got resources and appendices that try to bring legal definitions together. So I thought it'd be helpful to read quick, what does actual innocence mean? And they're bringing together Texas case law. Make this a little... It's kind of tiny. So again, this is from a post-conviction integrity unit in Texas. It might be different in other states. Actual innocence is a legal term to describe when a person is factually innocent. In other words, the person did not commit the crime for which they were convicted. In Texas, actual innocence cases can be presented to the court in 2 following ways. So this is how we can bring an appeal on an actual innocence issue. 1, the standalone claim of actual innocence based solely on newly discovered evidence, so evidence that nobody had available to them at the time of trial, also known as a Herrera-type claim of innocence. So this is coming from a case. This is case law. They're shorthanding it to Herrera. And then a schlup. So we get to say schlup a lot in this video. A schlup type of claim, which is a procedural claim in which the claim of innocence does not itself provide a basis for relief, rather is tied to a constitutional error. So the Herrera type claim requires applicants to meet a clear and convincing burden of proof. And now this is important. This is what we're going to see squabbled over, which has repeatedly been described by the Texas Court of Criminal Appeals as a Herculean task. Now, Herculean, average cat, average Jane like me, probably not very likely I can accomplish it, right? It's a very difficult task. Very difficult thing to achieve. Whereas the schlup claim requires applicants to meet the lower by preponderance of the evidence burden of proof. So not the same difficulty. They've got a little bit more here, wrongful convictions, saying that over the years, several cases of wrongful convictions have been identified, including faulty eyewitness identification, false or misleading scientific evidence, prosecutorial or official misconduct, perjury, false accusations, and false convictions. Usually wrongful convictions involve more than one cause. So I thought that was important to note. This is, again, the Post-Conviction Integrity Unit, acknowledging that, hey, these are common causes and usually there's more than one at play. Here we have DNA coming in as new evidence that helps us find the real perpetrator. We also have an issue with eyewitness identification. And then let's get over to the squabble. Now, the presiding judge is what we're going to look at first. That's Judge Shank. This is his concurring opinion. So they've all agreed. You know, they get this writ of habeas. You shouldn't be holding me. It's 7 judges total. We have 4 concurring opinions written. All 7 are like, yeah, grant this. It's granted. They agree. This man's innocent. Get him out of there. The concurring issues that we're going to see, the concurring opinions, are squabbling over something that would not hold back. Nobody's saying that Travis Cobb should still be in custody. So Shank here says, the court today grants applicant habeas relief, and I agree with that decision. I write separately to express my skepticism over this court's reliance on federal habeas case law in formulating the standards set forth in Ex parte Elizondo. So we're going to hear that name a lot. In Elizondo, so this is from the Texas Criminal Appeals from 2011, we cited Herrera and Schlupp. So we've got this case that weighs Herrera and Schlupp, the different standards and when to apply them. They cite here claims of actual innocence with alleged constitutional violations to recognize 2 types of actual innocence claim. So procedural or factual actual innocence. We held in Elizondo that the proper standard of review for bare claims of actual innocence like applicants is where there's, quote, clear and convincing evidence that no reasonable juror would have convicted him in light of the new evidence. In doing so, we recognize that in the context of federal habeas law, a bare claim of actual innocence fails unless new facts questionably establish innocence. Now, again, this is coming from Schlupp. So this is Herrera quoting Schlupp. Then we move on. Because the Supreme Court had not defined, quote, unquestionably established, but clearly indicated that the standard was higher than the more likely than not standard it applied in Schlupp, we held that unquestionably established must have meant the same thing as clear and convincing, and adopted that clear and convincing standard as our own. So we're going to see one judge, like, this is really where Judge Yeary, who's the one that the other judge is going to, like, yell at for 20 pages, Judge Yeary is going to take an issue with why we're even debating what the standard means. But to me, it's important, right? You guys know we saw Doug with his poster on why beyond a reasonable doubt, that 99.9%, like, it would be so unconscionable to really think that the one exception could actually be the true exception. But clear and convincing, preponderance of the evidence, what's the difference between being 50.1% versus 49.9%? This is really what these judges are going to be arguing here. And again, this is in the context of how it could define someone's innocence. So it's not it might be a small squabble over the standard, but the way that standard could be applied has huge ramifications. So that's why this Judge Shank initially decides, look, I'm going to write this opinion to address this. Properly characterized, the extraordinarily high standard this court relied on in formulating Elizondo review is actually the gateway to habeas relief in federal courts when those courts move to undo one of our judgments. It is not the gateway to habeas relief in state courts. In conflating the two, the Elizondo court may have created unnecessary tension between the federal habeas system and our state's jurisprudence by ignoring the underlying federalism considerations animating Herrera. As the Supreme Court itself has recognized, federal intrusions into state criminal trials frustrate both the state's sovereign power to punish offenders and their good faith attempts to honor constitutional rights. And that's a federal case, Brecht v. Abramson. When a state court, in contrast, makes its own good faith attempts to honor constitutional rights, the same federalism considerations and the same extraordinarily high gateway obviously do not exist. As we have our own state constitution and our own suspension clause, we would do well to establish our own standards for their recognition and enforcement mindful of our primary role and responsibility for the administration of criminal justice in our state. I recognize that we have not made a habit of applying our own constitution to examine questions of entitlement to habeas relief in our courts. given that federal habeas review under 28 U.S.C. 2254 exists as a backstop to, and generally requires exhaustion of, state remedies, precisely because that primary level of review includes both state and federal constitutional remedies. Our review should be independent and comprehensive. So, and I think this is important because, again, if we, putting Schenck, what I'm getting from Schenck's argument is, if we adopt the standard that the Supreme Court would use if one of our criminal cases or any state's criminal cases, everything available at the state level is exhausted and now we have to move up to SCOTUS. If we adopt the same standards, that, first of all, what's the point of having state and federal, for one? But two, it's just inefficient. It kind of makes what we do here at Texas' highest level of criminal matters. Again, this is essentially the Texas Criminal Supreme Court. They just call it the Court of Criminal Appeals. It's the highest level. It kind of makes what we're doing pointless if we just have these same standards and there's no difference. So for a variety of reasons, he's asking, let's establish something that we follow. Let's get clear on what we as a state, based on case law and maybe our statutes, decides is the standard for someone to reach for an actual innocence claim. I also recognize the difference between a more likely than not standard of review and a clearly and convincing one seems ephemeral. So he gets that it seems insignificant. Nevertheless, if presented with the conclusion that one of our own judgments is so afflicted, I would prefer to pause and ask the question of how our own Constitution would direct us to proceed. This tension between federal habeas jurisprudence that recognizes its intrusion into our state's sovereign power and our own habeas jurisprudence that nevertheless relies on the very cases that cut into our sovereign power highlights my concern with our opinion in Elizondo. But the question of whether we should re-examine Elizondo is not squarely before us today. It has nothing to do. We still think Travis Cobb is actually innocent. But I just wanted to raise attention here. Still, recognizing the potential conflict between the two bodies of law, the court should entertain the opportunity to re-examine our approach on actual innocence habeas claims in the appropriate case. So he's like, I want to table this. I want to put this out in the air because I think we should clarify. We should get some clarification, even though we're not being asked to. So that was the presiding judge. That was Schenck. I think did Schenck come into play recently, maybe with the TK case? Did he have to step in? Someone from the Texas Court of Criminal Appeals, I think, had to step in with something going on in the TK case. But I didn't really catch that. It's just something I saw and didn't really look at. Now, Judge Yeary is the one that's going to respond, taking issue with possibly reducing the threshold, the standard for someone to raise and reach what's required to prove an actual innocence claim, present it to the Texas Court of Criminal Appeals. Nice and short, but this is the one that we're going to see the other judge pull his hair out over. Also, a big shout out here. Thanks, Honorable Yeah That. Says it's wild how laziness or personal motive / bias leads to so many wrongful convictions, and most time leads to no accountability. Just a, oops, now you're free. Yeah, and that's the thing. I don't understand why that officer, I cannot imagine myself not volunteering the content. If someone asked me, have you ever seen that person have a cast, or that they had surgery, or any, a question like that, my first thing would be yeah, years ago, a decade ago. That's just the way I feel like I would answer a question like that. So I don't know how we didn't get that from that Park Place officer. And maybe they didn't know each other as friends. Maybe that officer recognized him for a different matter in the past and already had a negative impression of the guy. I don't really know. But in any case, it's just one of those things where you've got the guy in an officer's uniform saying, yes, I identified somebody. And in opposition, you have, it seems like a veteran and shout out to our veterans, but there's a stigma around veterans. I don't know how this veteran presented himself. We heard in the article that we had somebody in the trial make the misstatement or false claim that the defendant Travis Cobb was homeless. And a jury could, when it comes to weighing credibility, they could look at the officer in the shiny uniform as being more credible than the veteran, depending on how they presented themselves, saying, look, I hung out with this guy like the week this happened and he wasn't wearing a boot on his leg. And the jury, I think, just human psychology, a lot of people are going to trust what they hear from the officer. Maybe not folks here in this chat. I would say that there's people that it would be the complete opposite, right? I don't trust anything coming out of someone with a badge's mouth. I just don't trust them. But typically, I think with jury selection, prosecution tries to strike those types of people off the jury if it's apparent that they just don't trust law enforcement at all. So, yeah, but I don't know how we got there, how this officer was able to say, yeah, he's worn a boot before. Like, that doesn't, it's not constrained, it doesn't narrow it down, and it means nothing if it's years out of context. Just crazy. Yeah, shout out to that guy, Nick36. In parentheses here, almost like our justice system relies heavily on stereotypes. Yeah. To the point where, and one of my favorite appeals, and the appeal was over the sentencing. It wasn't over, I think it was just an appeal over taking the death penalty off the table, rather than like an appeal for reversing the conviction entirely. And I wish I remembered the name offhand, but in the sentencing phase of the trial that I'm thinking of, and it was only like 2 decades ago, in the sentencing phase, it's almost like another miniature trial where each side gets to present, the prosecution's probably trying to present aggravating circumstances, things that this person, this was in cold blood, it was premeditated, they have a history of doing this, they cannot be rehabilitated, there's a history of us trying to rehabilitate this individual and they continue to break the law, so we urge you to consider, that this person, there's no redeeming them, so vote that all elements are met for the judge to consider a death penalty sentence. And the defense will do the opposite. No, his family says they're a good person. They had a rough upbringing. So if you had a bad upbringing, that could be a mitigating circumstance. If there's possibility that you could get treatment, do some reintegration programs, the argument would be if over a certain period of time with work, if you can become a contributing member of society again, take something like the death penalty off the table or mitigate the severity of the sentence. And in this case that I'm speaking of, the prosecutors came in with statistics about demographics and rates of crime. And they presented that to the jury in this trial, and they voted in favor of allowing the death penalty, and judge chose to sentence to the death penalty. Because they had an expert witness come in and discuss statistics. So nothing related to the individual person that was on trial. Just statistics. So they have case law now in Texas. The Court of Criminal Appeals, it might have gone up to SCOTUS. I don't think it went federal. I think it was I think it ended at the Texas Court of Criminal Appeals, where they had to spell out, hey, you know what? It's extremely prejudicial for someone to use statistics to get a jury to return a verdict a certain way, or decision a certain way. Like, can you imagine that needs to be said, that individual facts and circumstances of a case a jury should not be deciding what to do with an individual based on statistics? That's crazy. That's just crazy to me that it had to be. But it's there. It's case law now. It's case law now. If I find the name, if I pull that up, I forget the podcast I first heard it on. It was like 3 Strikes. And it's a post-conviction podcast. But they talked about that case. It was a few years ago. So, But it was just crazy. Shayna joining us. Hey, Shayna. We've got Kiss and Pink saying hey to Survivor Speaks. So hey to Kiss and Pink and Survivor Speaks. Hey, Trikisha, good to see you. Let's see. Yeah, Chloe Albert's Revenge says, well, it's predictable and prejudice in my opinion. And Chloe Albert's Revenge put me on the other day and I missed it. I'm sorry, Chloe. There are new baby goats. So if you guys have heard me talk about the baby goats, or you joined us in the redirect 2 streams ago to Dottie, Bend It Like Dottie. Dottie has a little sister. Maybe we can redirect over there when this is done. We'll need it after the judge squabbling, because we're going to get to the judge squabbling. Go live stream. Let's see. They look like they're all sleeping, laying down right now. So go live stream. Put that in there. It was I will warn you, they also have a rooster. So it's like, it'll be calming. You get to watch mama goat, baby goat. And then all of a sudden, it's like very soothing. It's fun. It's nice. It's relaxing. It's adorable. It's heartwarming. And then all of a sudden the rooster just decides it wants to bellow for the next minute. So just be prepared for that. Be prepared for that a little bit. Not yesterday that I know of. Wait, what? The title, the thumbnail does say baby brother. Hold on, we're gonna stream snipe for like 1 minute. I'm gonna stream snipe for 1 minute. Yeah, there's a new baby. Right? In the box? I mean, maybe this, because they kind of look the same. They're both little. At midnight. Okay. Aww. And we have another one on the way. They come in threes. They come in threes. So yeah, very, very, you know, if you get upset hearing about stories, craziness, wrongful convictions, going to a goat stream after can be very, very good for the soul. So there is that in the chat. Thank you again, Chloe. This here from Judge Yeary, this is the guy that's going to raise the issue. Oh, Survivor Speaks. Hold on. Let me see what sticker. Thank you, Survivor Speaks. That's so nice. I got to look at what sticker it is. I love all stickers, but I still like to know. Yeah, we have a superhero with the cape and the avocado. Thank you so much, Survivor Speaks. Are you still doing Lori Vallow? Or are you going to start doing Karen Reed? We've got a lot of Karen Reed coverage. So I feel like I need to ask everybody if they're covering Karen Reed. Just to make sure I know. Let's see. Okay, so the last video I see as of now from Survivor Speaks is still Lori Vallow. So I think we're still on Lori Vallow for Survivor, but let us know. And that's a crazy case again. I mean, any case with the pro se with the pro se defendant always seems to have some craziness, but she is particularly chaotic. So there is that linked in the chat. I'm going to leave the goat stream live and see if you guys see me jump when the rooster squawks. And then Dolly, hi Dolly. Dolly says, Kat, great seeing you. So there is a status conference in the Courtney Clenny case today, guys. If you missed it last week, docket entry was added. The court received a letter from a friend. That's all it says. So there's supposed to be a report issued on that yesterday to the parties, and now there's a status conference hearing, like right now. But my joke is that Dolly sent the letter. He's the friend that sent the letter to the court. So big shout out to Dolly. Dolly's been doing a lot of coverage with Judge Fleischer. So I think most of you in the chat, if you weren't already familiar. with Judge Fleischer. You are now because you've watched over at Dolly. I know SteffJK's over there sometimes. Oh, you know what's crazy? Autosuggest, Dolly, I went to search for your URL. Autosuggest suggested the search Dolly Judge Fleischer. So you're getting worked into the search prediction algorithm, the search suggestions. And maybe we can go over there too. Goats or Judge Fleischer? So there we go. Oh, in Brooklyn, yeah, maybe they'll sponsor one goat to be named after anyone. All the names are so, like, cute and nice, and I feel like if the chat was to suggest a name, it would be, like, one of those, like, 5 or 6 name. Really, it would just be an out-of-place name. So that would be hilarious in its own way. Holy moly. So Yeary here says, I concur in the result the court reaches today. So we're going to grant this writ of habeas. Travis Cobb's going to get out of here. This was like March 25th or 26th. I write separately only to respond to the presiding judge's concurrence, Judge Shank's concurrence. I have made the point on any number of occasions that to call a claim, quote, actual innocence that is predicated on the court's opinion in ex parte Elizondo is a misnomer. So I just don't like us calling things actual innocence. And he cites himself. He says, oh my gosh, he says, on any number of occasions. And then he gives us like 1, 2, 3. We've got 3 cites to himself saying the same thing previously. Note that each of these was a concurring opinion. So he's saying I wasn't disagreeing with the ultimate outcome, the decision to grant a writ or whatever petition. I just kept raising a fuss every time about this misnomer and the quote actual innocence. I have no qualms about granting post-conviction habeas corpus relief to any applicant who can satisfy the current Elizondo standard. He quotes himself. He quotes himself instead of just saying it again. But I would not necessarily call that applicant, quote, actually innocent in doing so. If I accurately understand presiding Judge Shank's concurrence, however, it seems like he advocates for possibly granting post-conviction habeas corpus relief based on a standard that is even less rigorous than that which the court adopted in Elizondo. He seems to suggest that it could be appropriate to apply a level of confidence even less onerous than, quote, clear and convincing evidence to gauge whether, in light of newly available evidence, a rational jury would still have convicted an appellant. And so he's citing the concurring opinion we just read, but this specific line. I, ... recognize that the difference between a more likely than not standard of review and a clearly and convincing one seems ephemeral. Now this footnote here, and they're citing here Article 1107, Section 4A2, permits an applicant to bring a subsequent writ application when, by a preponderance of the evidence, a violation of the United States Constitution has caused a jury to convict the applicant when no rational jury otherwise would have found him guilty beyond a reasonable doubt. Texas Code of Criminal Procedure. But this more likely than not level of confidence only permits a subsequent application to proceed when there's an independent constitutional violation that causes the applicant to be convicted when he otherwise could not have been. It is, in other words, a gateway provision and does not speak to the appropriate level of, and I hate when the footnote goes to another page, confidence that should be assigned to grant merits-based relief on a bare claim of so-called actual innocence. And so-called is his own words there. So, if that is what he's suggesting, I cannot agree. So he doesn't want to touch the standard. More specifically, he doesn't want the standard to be lowered. And again, in situations where it's not a constitutional issue, right? So here, Travis Cobb was really arguing there's new evidence that wasn't presented to the jury. With this, we can't be confident in the outcome should a new jury have the same information available to them. That was really his focal point issue here, and all the judges agreed that this new DNA evidence was compelling. Presiding Judge Schenck also seems to invoke principles of federalism to justify his suggestion. And we get another footnote. The presiding judge suggests that we could proceed to review a bare claim of, quote, actual innocence under whatever level of confidence standard we might deem appropriate as a matter of construing the Texas Constitution. Even if he is right about that, and I'm not 100% certain that he is, it would not mean that we should establish an even lower standard than that which was adopted in Elizondo. So again, his disagreement is whatever it is you're saying, we should not go lower with the standard. We should not go lower with the standard. Let's see, where were we? He argues that we did not have to defer to the federal standard for proving actual innocence, which serves in that system only as a, quote, gateway for federal review of independent constitutional error in state court judgments. I do not disagree with him, at least with regard to that. But evidence of actual innocence in that context provides only a mechanism or a vehicle, a gateway, if you will, to obtain federal review, not merits-based relief, notwithstanding ordinary obstacles to such a review arising from procedural default or lack of exhaustion at the state court level, or from the fact that the independent constitutional claim was raised in either a successive or an abusive federal writ petition. And here we're getting to Schlupp v. Dalo. Describing actual innocence as an exceptional basis for reaching claims in federal habeas that have been procedurally defaulted in the state courts or brought repetitively or untimely in the federal court. Such a federal applicant obtains review because of his showing of actual innocence, but he does not obtain relief on that basis. Relief, even in that system, is not obtained at a demonstration to any level of confidence that the applicant might be innocent. Instead, relief is dependent on whether an applicant can show that his conviction was also sullied by some independent constitutional defect that probably caused the conviction of an innocent defendant. And so really this seems to be, in my opinion, it seems like this judge is leaning into the federal argument that Schenck made, in his opinion, because he wants to be able to lean in and say, well, if there also isn't a constitutional violation, a specific constitutional violation, then it doesn't matter anyway. But that wasn't really the sole argument that Schenck was putting on the table. And again, Schenck said, look, this isn't really the matter before us. Nobody's asking us to question this, but I'm raising a question. I'm raising a concern here, and I think it's something that we should have on our minds. A bare claim of so-called actual innocence, in contrast, as we have in Texas, does not require any independent constitutional defect to be shown to justify relief. Instead, it is a merits-based showing of actual innocence itself that demonstrates a violation of the federal Constitution. And that's the Herrera case. It is no surprise then, let's read this footnote. Oh God. It's a whole page. Herrera itself did not, at least it's all on one page though. Herrera itself did not explicitly recognize bare actual innocence as a due process violation. The rooster's going off. Instead, it merely assumed a due process right to relief in such a circumstance, and simply held that the threshold showing for such an assumed right would be extraordinarily high. A bare majority of this court nevertheless held that actual innocence could be asserted as an independent due process claim. So he's emphasizing here a bare majority. So, I mean, that would be what, 4 out of 7, I would assume? Because there's 7 of them, so I would interpret that to mean 4 of 7. Nevertheless held that actual innocence could be asserted as an independent due process claim. That's Elizondo. The court did so largely on the strength of its earlier observation in State ex rel. Holmes, Third Court of Appeals, that 6 members of the United States Supreme Court had opined, in separate opinions in Herrera, that execution, at least of an inmate who was innocent of committing capital murder, would violate due process. But since both Holmes and Elizondo were decided when the Supreme Court was again faced with the claim of freestanding innocence in House v. Bell, a majority of the Supreme Court once again declined to resolve whether such a claim may be entertained under the Due Process Clause. The Supreme Court once again concluded that, in any event, House had failed to satisfy Herrera's undefined, extraordinarily high burden. Also, the only separate opinion in-house failed to advocate that actual innocence should be recognized as a due process claim, and that's citing Roberts. And Chief Justice Roberts said, "I do not believe that House has satisfied the higher threshold for a freestanding innocence claim, assuming such a claim exists." Well, okay, I don't like this. So, Yeary seems to be arguing also Chief Justice Roberts didn't explicitly advocate that actual innocence should be recognized as a due process claim. Now, that could be a fair argument, but I think this quote doesn't match what his characterization of this quote. So, if nobody in the Supreme Court has ever advocated or explicitly said something, we can't rely on, it's not going to be there for us to rely on as some type of precedent when we want to use it in an argument. But here it says, "I do not believe that the House has satisfied the higher threshold for a freestanding innocence claim." This to me acknowledges that Roberts and the Supreme Court acknowledges that there is a pathway, a gateway to make a freestanding innocence claim. So Yeary's characterization of what Roberts is saying, the argument he makes doesn't follow. It's illusory. Sure, he's not advocating to change the threshold, but his statement here relies on the existence of the threshold to bring a freestanding innocence claim. And if there's a threshold for something, that means there's a pathway to it. So, I don't like this characterization here in this very long footnote. But what does he continue to say? "It is no surprise, then, that the United States Supreme Court has observed that the threshold showing for such an assumed right would necessarily be extraordinarily high. After all, an applicant claiming a right to relief on a bare claim of actual innocence would have presumably suffered no other constitutional defect in his trial that would standing alone render a retrial appropriate. It would only be the perception that the result of the trial was nevertheless unreliable, indeed inaccurate, that would justify a retrial in such a case. Under those circumstances, we should be reasonably, if not perhaps closer to absolutely certain, that the result of the first trial, otherwise unsullied by any constitutional defect or deliberate prosecutorial misconduct, was nonetheless inaccurate before it would be appropriate to order a new one." As Judge Price aptly observed in a concurring opinion in 2011, and this is from the Texas criminal. Judge Price we're no longer at SCOTUS with this quote. This is still Texas Court of Criminal Appeals, their criminal Supreme Court. "Actual innocence is concerned with the accuracy as opposed to the fairness of the original proceeding. If the applicant can produce new evidence that affirmatively just demonstrates his innocence and does not simply call the state's original evidence of his guilt into question, and factoring that new evidence in with the trial evidence, the habeas court concludes by clear and convincing evidence that no rational jury would have convicted him. He is entitled to relief. That is a Herculean burden, we have said, and it is meant to be. Otherwise, trials would cease to be the so-called main event of our adversarial criminal justice system, and the state would never be able to depend on the finality of its convictions." So this to me just goes to, it's emphasizing that the jury is still the finder of fact. So whether someone wants to say that their trial was unfair, if they can't demonstrate, it's not mentioned in this paragraph, but if they can't demonstrate like a constitutional issue, a procedural issue as a matter of law, they can't just say it's unfair because of the way the jury made a determination. They're the fact finders. So we don't want to take away the sanctity of a jury's decision as a finder of fact, or I guess a judge in a bench trial. But how this comes into play here in the confines of this case with Travis Cobb, and I saw I think it's David in the chat asking for the case. We are looking at I'll get the link. So in the chat, that is what we're looking at, basically the concurring opinions in relation to the Texas Court of Criminal Appeals granting of the writ of habeas for Travis Cobb. Where were we? So as for myself, I have suggested, despite my reluctance to use the nomenclature of actual innocence in many instances, that I would still be compelled to vote to grant relief on due process or due course of law grounds when an applicant is able to meet the extraordinarily high burden established in Elizondo. But anytime a court grants relief from a final judgment of conviction for a felony offense, it is a serious decision that deserves serious consideration, and it should never be handed out on a demonstration as easy to meet as the preponderance of the evidence standard. Instead, it is altogether fitting that the standard should be set at an extraordinarily high level, higher, indeed, than most of the mere gateway standards identified in the federal habeas corpus cause and prejudice jurisprudence. So he wants the standard higher. And I cannot agree that the court's decision to identify the appropriate level of confidence required for such relief in Elizondo to be by clear and convincing evidence was too rigorous. With these observations, I respectfully concur. Okay, so here's the footnote. I was wondering where it was. Okay, so it was right at the end here. So this footnote spells out the granularity of what Yeary is taking issue with over Judge Shank's opinion. Presiding Judge Shank seems to suggest that a level of confidence of more likely than not might be appropriate, and that in any event, the difference between that and clear and convincing evidence seems ephemeral. So this is the second time we're getting him quoting this, because he quoted it in the body 2 pages ago. Concurring opinion of Presiding Judge Shank at 4. I disagree. If we simply ask ourselves if there is a better than even chance, greater than 50%, that a jury, equipped with newly discovered exculpatory evidence, would not have found an applicant guilty beyond a reasonable doubt, that leaves as much as a 49.999% chance that the jury would still have found him guilty beyond a reasonable doubt, and convicted him anyway. Even if some people would now be willing to describe such an applicant as probably innocent, that is not a sufficient demonstration of inaccuracy as to justify overturning the result of what was otherwise a fair and constitutionally unblemished trial. So, he's taking issue with the slight flip-flop distinction, and, you know, if there's a possibility that somebody could still convict him, then we shouldn't grant an actual innocence. This specific case, though, what is the new evidence? What is the new evidence? The new evidence is the cup that the perpetrator on the video surveillance footage was drinking out of, that the police obtained and secured and had it in evidence, you know, presumably chain of custody, I know, but if they didn't take it that day from the Walmart, when else would they have taken it, right? DNA matches this other guy, not Travis Cobb. So under this argument, Judge Yeary is saying, you know, we shouldn't have the ability to say that this degree of confidence is all we need here. It should be stronger. We shouldn't be weighing issues of fact. But it's DNA evidence. And I would also argue, I think this judge is missing a key thing. Is this really a new evidence issue? Technically, the testing results would be new evidence. But the material of which the state could have tested at the time of trial, before trial, that cup is not newly found. And if you take that into consideration here, I mean, I just don't understand how we have these 6 pages. This to me just seems like we're racking up yet another gripe. This Judge Yeary consistently gripes that it's too easy. It's too easy for the very minuscule small amount of cases that even get to us, that we may have fractionally, a small fraction, decided, yeah, innocence, actual innocence. We should be stricter on this. And he's just griping again. That's all this seems like. And the next time this happens, I'm sure he's gonna cite himself in this opinion in his next opinion. So, we have a short opinion. Okay, well, before we get to the slapback, we do have a short response from Judge Newell. It's short. They say any controversy in this case is self-inflicted. The state agrees that the applicant is actually innocent. This court, the habeas court, also agrees and recommends granting relief on actual innocence under the legal standard for actual innocence relief, articulated over 28 years ago in Ex parte Elizondo, holding that the petitioner must show by clear and convincing evidence that no reasonable juror would have convicted him in light of the new evidence. Do we have that here? Do we have that here with this DNA? Moreover, every member of this court agrees that the applicant is entitled to relief under Elizondo, and neither party is asking this court to revisit our holding or otherwise adjust the standard for actual innocence relief. Furthermore, no one points to any indication that the current standard for actual innocence relief under Elizondo is unworkable. And that's true. So Shank wasn't saying it's unworkable. He's just saying, hey, there's like this ephemeral difference. Just saying. Maybe we should get clear on it. And here, this footnote cites Garcia v. State from the Texas Criminal Appeals 2019, recognizing that this court follows the doctrine of stare decisis to promote judicial efficiency and consistency, encourage reliance on judicial decisions, and contribute to the integrity of the judicial process, and noting an exception is made when the court determines that the precedent at issue was poorly reasoned or is unworkable. So, a footnote here, stare decisis, if we're not questioning Elizondo, this controversy in these concurrences is just the court choosing to squabble with itself. Because no one's asking, no one's raising an issue or saying that there's something wrong, unworkable about Elizondo. And I truly think in reading Shank's opinion, he said it himself that this wasn't really an issue that we need to square here with this case, but it's something that we should think about. Furthermore, the court routinely denies actual innocence relief and only grants on that basis when an applicant can carry the Herculean burden necessary to establish that such relief is warranted. Let's see. What is the substance here? Compare Ex parte Reed, which granted actual innocence relief under Elizondo, with Ex parte Brown, denying actual innocence but granting relief on other grounds. And so this judge is saying, like, look, under Elizondo, we have a mechanism to deny actual innocence and still grant relief, or we have the choice, we have discretion, we have the room, it's workable, we can grant both. That a judge on this court does not want to so this is a little scathing here. This is just short. It's brevity here compared to the other response that we're going to get to. That a judge on this court does not want to declare an applicant actually innocent when the applicant establishes actual innocence under the controlling legal standard does not render the standard itself problematic. So the Judge Yeary, is being problematic, he's being controversial, but the standard isn't the cause of that. The standard isn't the issue. It's just Judge Yeary being Judge Yeary. And since Elizondo, there have been no arguments lodged by practitioners to revisit the standard, despite numerous invitations by members of this court. Also, by way of contrast, the court has already tried and rejected the application of a higher standard, so we're not going higher. That standard was unworkable because it's impossible to meet. Because how do you get higher than Herculean? What's after Herculean? As we explained in Elizondo, if habeas corpus relief is to be conditioned upon a finding that no rational juror could convict the applicant after introduction of the newly discovered evidence, it becomes theoretically impossible for any habeas applicant to sustain his burden, because exculpatory evidence can never outweigh inculpatory evidence under this standard of sufficiency. Right. So if we have to prove beyond a Herculean like that something is exculpatory and weighs more than the inculpatory evidence, there would never be an opportunity for post-conviction actual innocence claims. Raising the burden of proof to eliminate the weighing of the exculpatory evidence against the record creates the same theoretical impossibility by a different name. The current standard set out in Elizondo is a high but workable standard, not an impossible one. And of course, we cannot forget the reactions from the legislature and our sister court to our recognition of a claim for relief based on actual innocence. Since Elizondo, the legislature has codified this court's ability to make a factual finding of innocence, of actual innocence, for purposes of compensation for wrongful convictions. Okay, so I mentioned that at the beginning of the stream. Do they give us the specifics? We looked at the pardon opportunities, but remember I said some states have legislation now that there could be compensation for wrongful conviction or vacating of a sentence. The sentence shouldn't have been as long as it was, and you did more time than you should. But there could be a different lower, like a floor, like it's higher. You start higher when you have an actual claim of innocence and you're entitled to compensation. So I guess Texas does have that. What was the number? 103 A2B. It was 103.01. All right, full pardon, been granted relief. So this one, okay, has been granted relief in accordance with the writ of habeas corpus that is based on a court finding or determination that the person's actually innocent of the crime for which the person was sentenced. So claimant's entitled to compensation and health benefits coverage. Does it tell us what the coverage is? Yeah, so they can get group health benefit plan coverage. Shout out to that. Spouses and dependents can be included. Obviously, compensation for any sentence that they were in prison for, any time that they were in prison. Deceased person's entitlement can go to the estate. And shout out Adventure Aaron in the chat. I believe you mentioned you're still the estate for Marcellus Williams. You guys, there must be something similar in Missouri that allows, if a deceased person was entitled to, if the person was entitled to relief, then their estate is also entitled. There's an avenue for them to obtain that compensation. So if Adventure Aaron's in here, I believe they're still pursuing, even though Marcellus Williams was tragically executed, in my opinion, extremely tragic. He's gone, but there's still a reason to fight in the post-conviction space for a court to grant relief in his case, because the estate could benefit. So, a whole bill. Okay, so Adventure Aaron says we're trying to pass a bill to allow it, so we're trying to get it codified. That's amazing. You have me on X, so just if you do a petition that people can sign, we'll of course share it in the chat. So that's super awesome. But yeah, so this stuff makes a big difference. Like there's a trickle down, right? Actual innocence is different than someone just being exonerated without that actual innocence finding, right? Because now there's different entitlements. And the state's responsible for it. And unfortunately, when the state's responsible for compensation, it's really taxpayer money. And that brings me to the circular argument that that's why we should care to get it right in the first place, right? It's not just about judicial efficiency. If the end result is the public has to pay for police and prosecutors, agents of the state, not getting something done right or not caring to do things right the first time around, not only are you, taking away an individual's freedom for however many years. I mean, 6 years isn't 40 years, but 6 years... What would you guys do if you were in jail, in prison for 6 years, wrongfully convicted, and you got out today? How different would your life be if the last 6 years, from today, 6 years back from today, you were in custody for something you didn't do, and you just walked out the door today? How different would your life be? I'd say a year. I'd say 30 days. You could lose your job and lose your apartment in 30 days. You could start getting late payments and stuff in a 30-day window. 6 years is no joke. So we got that. I appreciate this. What was it? Judge Newell Yeah, Judge Newell, including that footnote there. And also shout out to Aaron. Get the fight going. Get that bill passed in Missouri. Let's see. We did pass the bill to increase compensation, and this new bill no longer requires DNA exoneration to be compensated. So all compensation should be a little simpler. And to me, this means you're kind of that threshold, that barrier, you know, DNA exoneration typically can get someone to a court's finding of actual innocence, depending on what the DNA evidence shows, the new DNA results. But this expands the ways we can get there. And this is great because one of the problems that, you know, when you think about the Innocence Project, they really focus on cases where there's DNA available that either wasn't tested fully or wasn't tested at all. That maybe if they had access to test those things now, there could be, the results could show innocence. But they don't really go after cases where there isn't DNA available for testing. There are plenty of people that are sitting in custody where there just isn't material with DNA to be tested, right? So if there's legislation being enacted in Missouri and in other states that could provide pathways to relief when, you know, facts at issue in the case, maybe we had false accusation. And you guys, I'm sure everyone's heard a story of someone on their deathbed just says like, yeah, I lied on that person years ago. I mean, that person, there might not be a pathway for them to get the same compensation that someone that was exonerated through DNA evidence would be able to get, even though they did time for no reason. They're completely innocent. So that's really important. And every state has stuff different. So if you're in the United States, and obviously other countries, I'm sure they might have similar things, but way outside my realm of even just passing familiarity. But try to just look up like post-conviction and your state name and see what resources you can find. It is something that a lot of states are starting to formulate and develop and put together systems for. Where were we? Here. So since Elizondo, the legislature has codified this court's ability to make a factual finding of actual innocence for purposes of compensation for wrongful convictions. And it later expanded the ability of trial courts to render a factual finding on actual innocence with an agreement by the state when relief has been granted in accordance with a writ of habeas corpus. So here we have the finding of actual innocence, and we also have the relief granted. For its part, the Texas Supreme Court has recognized that compensation for actual innocence relief is appropriate even when applicants establish innocence under the lower schlup-based innocence standard. The concern about the standard for establishing innocence relief is a manufactured dilemma. And yet, we are told that following binding precedent from this court, when no one is asking for us to do otherwise, demonstrates a lack of humility. All right, so we're taking a little bit of issue here at Judge Shank, that making arguments on behalf of the state, and this next part is at Yeary, that making arguments on behalf of the state, or maybe this was about Yeary. Is this saying a lack of humility to the state? Oh, is this, I think Judge Newell's saying no one's asking for us to demonstrate humility towards the state, except for Yeary. Oh, I like that. That making arguments on behalf of the state to deny relief, even when the state is agreeing that the legal standard has been met, is an act of judicial restraint. What are we getting here? Oh, okay. So, going after Yeary's comment here in the footnote says, this is Yeary's quote, "In my view, we, judges on this court, lack a humility approach." This is hilarious. Judge Newell. So Yeary's like, I've been saying the same thing. Here's all the times I said it. And Newell is now going to an older case. It's Shaney, where Yeary had a concurring opinion. And Newell is referencing something Yeary said then. Yeary said, "In my view, we, judges on this court, lack a humility appropriate to our true station when we declare to the public that an applicant is actually, and thus factually, historically, and morally innocent, when, in factual, historical, and moral fact, he might very well not be. If the requirement is factual, historical, and moral certainty, it seems we should require that the conviction stage, rather than allow a wrongful conviction to stand, even though the defendant might very well not be factually, historically, or morally guilty. Oh, Newell is firing shots. Okay, I thought the other opinion was the scathing one. This is pretty scathing. This is scathing. Newell has been griping about Yeary, saying, we don't have enough humility for the state, for the prosecutors, and the work they have to do to actually get a conviction that someone's guilty. Oh, my goodness. You couldn't have told me that this footnote would be this good. Citing him right back. If you missed, there's a link in the description that links to the decision, the hand down of this decision. It has all of the concurring opinions. If you go back, we looked at it already. Yeary cites himself like 4 times. Oh, this is so good. Oh my goodness. Newell is saying, you're an even bigger simp for the state than the state is for themselves. Hold on, let's look up Judge Kevin Yeary, just so you guys, he's the middle person on the thumbnail of this video. But guys, this is Kevin Yeary. This is who's getting slapped in the footnote. Oh, goodness. And Oceana has always been at war with Eustasia. If we are truly concerned with efficiently resolving our cases, then we need to stop making up reasons to re-examine our precedent when the parties themselves do not ask us to do so. With these thoughts, I join the court's order granting actual innocence relief. So there we go. There we go. Yeah, that guy Nick says, dang, dude, we all defer to prosecutors, but you're being extra. Yeah. The girls are fighting. A true bench slap. Brooklyn says this is crazy. Yeah, Look, I focused all the way in. I think I saw 22 pages and said, ooh, Richardson is mad. But so was Newell. Newell was marinating on another concurring opinion from another case from Yeary and just let it all out in that footnote. So we're still going to get to Richardson's here. I think Richardson spells out a little bit more. It'll be more digestible for me, hopefully for you guys. The back and forth on the case law and what's really at issue or not. Oh my goodness. Oh, this is cool. So, and I think that without knowing the whole context of the conversation Brooklyn and Aaron are having here, Aaron says to Brooklyn, Texas gave me some ideas, though, because Missouri doesn't provide health care and actual innocence cases often take so long that clients are 50 years plus and spent 20 years receiving substandard health care. Yeah, so they're going to need it more than your typical individual at that age. And then there's no pathway for them to obtain it. So, yeah, that's awesome. And that's why, like, people are like, you live in Florida. So Georgia stuff, I lived in Fulton County for a little bit. My brother still lives there. So why are you caring about Fulton County? There was a little bit of reason, personal reason. Why am I looking at stuff in Texas? I don't know. But it's interesting. And beyond it being interesting, there was something useful that could actually become impactful. Proposed legislation, hopefully actually passed. And shout out to Aaron and everyone you're working with to, like, advocate for that. Hold on, I hear the goats going crazy. You guys know I have the goats in the other window. What's going on? It's surprisingly calm when you look at it. I think they're just telling the rooster to shut up. I haven't had a jump scare yet, but we're going to see if we get one. Tat Clouds, thanks for becoming a member. I thought you've been green before. Chloe with the goat update says, last night the mama goat kept talking and my English bulldog, very cute, kept answering. She started doing zoomies back and forth looking for the noise. It's super, super cute. I know you have like Chloe as your image. Like one day if you ever want to like profile picture your bulldog for us, let us see. That'd be super, super awesome. And then Chloe Albert's revenge with the phonetic. Shank. Judge Shank. Did the Shank say YSL on it? Judge Whittaker to Adrian Love. Classic. And were you screaming out the window yelling, I did this for YSL? Definitely good moments in that trial. Speaking of Shanks, if you guys have caught wind of all of the indictments, first was really the Robert Brooks beating. You know, he was an inmate and he was killed, and then there was surveillance video of, I think it may have been more than 12 people in the video, but 12 individuals were indicted. 12 corrections officers were indicted, most charged with murder. One guy's charged with just like tampering with evidence, but most are facing murder or manslaughter or both charges. Yesterday, another indictment came down for the death of a different inmate at a different facility, also in New York State. I think another 11 or 12 individuals were indicted. And yesterday I saw several anecdotal stories from members in a Facebook group following issues in the New York State Corrections. I forget the acronym, what it stands for. But stories where people have heard, or someone that used to work there said they were instructed to, and that's why they no longer work there. And these are Facebook users. I don't know the credibility of the claims, but the corrections officers, as a strategy in 2 facilities in New York, were recommended by their colleagues, their coworkers, to carry a shank on them in case they needed to say something was done in defense. And it's one of those things I wouldn't say in the open air without really having proof, but when you have a series of these indictments coming down, and comparatively seeing what goes on with the Fulton County stories, and we get this DOJ report on Fulton County's Rice Street and other facilities, you know, we have claims and reports from the employees that the victim was doing XYZ when officers were trying to do ABC, and then the video shows the opposite. I think it's important for us to hear the anecdotes that people might walk around with shanks in case they need to plant it on somebody to justify a riot or fighting with an inmate. Just crazy. Kay Tally says, I'm glad to see you back, Kat. Speaking of dogs and pictures, we have Kay Tally here in the chat. Good to see you, Kay Tally, and good to see the pup. And BigBabyJane, good to see you. BigBabyJane says, I've missed you guys. We miss you too. You're always missed when you're not here, but you're welcome to pop in whenever. Don't ever feel like a stranger. Oh, okay. Thank you, Chloe. Chloe says NYSCD, so New York State Corrections Department, as opposed to the New York City Corrections Department. So, yeah, and I think both cases were state corrections that I'm speaking on. So, and I wish I could remember, it just happened yesterday. Messiah Nantwi was the individual, the victim. So that indictment came down yesterday. And then over here, and again, those stories especially, right? Someone, and this is different, the issue there might not have been a wrongful conviction, but imagine being an individual that's in the process of an appeal. You're fighting to appeal your conviction, and then you end up dying in custody at the hands of the corrections officers. What's the remedy then? Because we can't even get to a point where we can complete our argument to an appeals court. That, like, you can't file I can't imagine a circumstance where you can file a writ of habeas corpus when you're deceased, because a writ of habeas corpus is, you shouldn't be holding me anymore. You don't have the right to hold me. Here's why. You can't make that claim anymore. You no longer have that vehicle to justice. So now you're denying the estate something that they may have been entitled to should an individual have been able to go through with their appeal. The justice system is like a long and tangled web. Here we have, speaking of long, maybe not tangled, we have Richardson here. This is the opinion I thought was going to be the spicy one, and maybe Newell's will take the cake, but we'll see. We've got 22 pages here from Judge Richardson. In this case, the state and the habeas court agree with the applicant that he is entitled to actual innocence relief. Indeed, the state actually knows who actually committed the crime based on new DNA evidence. Despite that, in an unsolicited crusade now lasting almost a decade, a member of this court continues to advocate that the Elizondo standard is not rigorous enough to identify the actually innocent from the hundreds of non-meritorious cases this court has received. So Richardson is like, yeah, we get hundreds. It's like a 1 to 100, 10 to 100. But we do get actually innocent, right? So just because there's also a bunch of non-meritorious claims doesn't mean we should be crusading for a decade to make the Herculean burden even stronger, whatever that means. This is even funnier after reading that Yeary was citing himself over cases from years ago. This specific unsolicited crusade is specifically Yeary's individual crusade. The 30-year established burden is a Herculean standard, with the burden resting solely on the applicant. Yet, Judge Yeary's familiar concurrence continues to advocate that Elizondo is not rigorous enough. Familiar concurrence! Oh, guys. Oh my goodness. It is now time to raise the bar and make it more difficult for applicants to obtain that relief, ? One might ask, why now after 30 years? Has either side asked us to do that in this case? The answer is no. In the 30 years applicants have been required to meet that Herculean Elizondo standard. Has any county attorney, district attorney, oh, this is beautiful, the state prosecuting attorney, or AG asked us to revisit the standard? Nobody from a prosecutor's office, nobody from in the capacity, in the role of a prosecuting body has ever asked us to lift this burden, or to raise this burden. Nobody. So why is this judge? Why is this judge being a simp? He's taking the too long didn't read version that Newell wrote, real short and sweet, and he's spelling out how ridiculous it is. Nobody has asked for this. Again, that answer is no. In this case, the state is not asking this court to raise the bar for actual innocence, nor is it even challenging the Elizondo standard. They agree this applicant did not commit the crime, and they know who did. When is it proper for judges on this court to be stronger advocates for the state than, well, the state? And this is where, guys, this is the first concurring opinion I read. It's actually the last filed. I got to this line and I said, a tweet isn't enough. I read this line and I said, oh, and I said, we've got to do a video. When is it proper for judges on this court to be a stronger advocate, simp, for the state than the state themselves? This is just beautiful. This is just beautiful. It's a great question. And I have my unsent tweet like sitting here. I never sent it. I was busy highlighting and I got to that line. And I said, here we go, chat. Here we go. Oh, wait. We have a footnote. Okay, so this footnote says it violates due process when a judge fails to be impartial and hold the balance nice and clear and true between the state and the accused. So guess what? Yeary? Guess what, Yeary? You're quabbling over, oh, there's no constitutional issue here. Guess what this footnote's pointing out very subtly, loudly to a judge. Subtly, if you're not paying attention. Here's the constitutional issue. The constitutional issue is coming from inside the house. It's coming from inside this court because we have a judge failing to be impartial and simping for the state. So if you want to talk about constitutional issues, here's a big one. Oh boy. Applicant Travis Cobb was convicted of an aggravated robbery in San Antonio, Texas, and sentenced to 25 years of incarceration. So if we didn't solve this, he would have been in there for like 14, well, he did 6. 19 more years. After spending 5 years in prison, new exculpatory evidence, including DNA tests from a cup the true culprit was recorded drinking from, clearly and convincingly shows applicant is actually innocent of the crime he was convicted of. I join the court in that finding. I write separately to address the claim, though not a genuine issue in controversy, that applicant should not be called actually innocent because he has not proven it beyond a reasonable doubt and that the Elizondo standard is insufficiently rigorous. So we're going to get into some facts of the case, and we get, I'm assuming this looks longer than the article we looked at. And I'm going to mute the roosters. I got to mute the roosters. I'm losing my focus here with the roosters. Oh my goodness. So facts of the case. In the... Okay, hold on. Chloe posted a dog post on channel page. So now we have the Honorable Mod, Chloe Albert's Revenge. And I think, actually, it gave me a quick way to pull up your channel. Oh, here we go, guys. Oh. Oh my god. Switch StreamYard. StreamYard's not switching my screen, is it? Do you see? Okay. So we have Maggie the Bulldog on the left, and then Zoe the Pitty on the right. They're very, very, very adorable. Thank you for posting this. I love this. And I love the dog prints back here. This is super, super adorable. So yes, I didn't need you to drop your link because I was able to find it, but have a wrench anyway. You deserve it. In July of 2017, a suspect, not Travis Cobb, entered a Walmart in San Antonio and began concealing merchandise in his backpack. The suspect was a white male with a beard and wearing a medical boot on his right leg. The suspect's visit was recorded in a series of Walmart surveillance video recordings. Though somewhat grainy and pixelated, surveillance footage shows that the suspect was completely bald to the point that his head was shiny and wearing shorts and a short-sleeved shirt. It also recorded him drinking from a styrofoam cup as he moved. Why is styrofoam capitalized? Is styrofoam a copyrighted thing? Like Band-Aid? Surveillance video then shows the suspect wearing a backpack and moving to exit the store without paying for the acquired merchandise. As the suspect neared the entrance, David Gamez, I could be butchering that name, a loss prevention officer employed by Walmart, began pursuing him. Gamez managed to confront the suspect just outside the exit and grabbed onto his backpack. The suspect then wiggled out of the backpack harness and used a bladed object to cut Gamez, causing significant injury. Gamez was hospitalized for the severe wound he suffered. The backpack, the stolen merchandise, and the styrofoam cup were recovered. No usable fingerprints were recovered from the cup, and it was not tested for DNA. However, a still photograph of the back of the suspect as he was leaving the store was generated from the surveillance video and distributed to police officers. Yeah, so, like, I don't know, in all of that, they couldn't get one of his face. Officer Prikshat of the San Antonio Police Department saw the image, told one of the investigating detectives that it resembled applicant because he had seen applicant wearing a leg brace after applicant had fallen off a ladder sometime in the past. Who is, what a name, first of all. What? Is there, like, other stories of this guy? Because I feel like this can't be the only suspected, this officer. This can't be the only time something sketchy has come from this officer. Sometime in the past. He further claimed that applicant was homeless, matching characteristics associated with the suspect. A photo lineup of 6 photographs included both bearded and non-bearded bearded males was generated by Officer Gallegos and shown to Gamez in a car outside his residence. Out of the 6 photographs, Gamez positively identified applicant as the perpetrator. On the photo identification form, he handwrote that he was certain of his identification of applicant based on facial features such as facial hair and the subject's skin color. Applicant was tried and subsequently convicted for aggravated robbery, which was affirmed on appeal. He was sentenced to 25 years of incarceration, to which he served 5 years before being released on bond during the pendency of his writ application. So he had some bond. Okay, cool. That's actually good to hear. So it was a 6-year period. He served 5, but was on bond at least for some of it for this application. So shout out to that being granted. And I would imagine that it being DNA evidence, DNA testing, was a very strong factor in this. And possibly they'd already spoken to the woman who said, oh, I know that woman that walked in that day, and I know the man she was with. I know who actually did the crime. So this, I don't think your average person filing a writ application, I don't think bond would be granted for them. I think that's exceptional. The record on writ now reveals new facts that affirmatively point towards applicant's innocence. We now know that Officer Prakeshaw's identification of applicant based on a still photo of the back of the suspect was inaccurate and misleading. Although Officer Prakeshaw did not lie about knowing the applicant suffered a leg injury and that he had seen him wearing a brace, he omitted that he had not seen applicant in years and did no subsequent follow-up to confirm that this information was still true. We have a footnote. At the time of this applicant's arrest, applicant had an ongoing civil rights lawsuit against the City of San Antonio Police Department and the City of San Antonio for the excessive use of force arising from an unrelated incident. The lawsuit eventually ended in a settlement. Whoa! Hold on! That's not insignificant. Big shout out to this judge for including this in the footnote. Because to me, this is a signal that the judge thinks that this is not insignificant. Isn't that funny? Isn't that funny? You know someone's got a civil rights lawsuit against your team. And it's not clear here, but there is, depending on how this case was filed, this lawsuit could have been against, it's at least against the municipalities, right? Which would mean that if there are named officers, they're probably being sued, at least in official capacity. But possibly the lawsuit could have named individual officers in their individual capacities as well. That's not apparent here. Maybe we can take a dive into that on Twitter. But isn't that something? Isn't that something? This officer just knows it was that guy. We're going to put his photo in a lineup. We're going to get him gone. Because it's probably not easy to fight, your civil action, your civil rights lawsuit, if you're going to be locked up for 25 years. Guys, this is like, if it was appropriate to put emojis in an opinion, this should have those red flashing light emojis right here, like 3 over here, 3 at the beginning of the footnote, and then 3 at the end of the footnote. Like, and now I feel nicer. I was like, maybe I'm being a little judgmental. Maybe the guy's just stupid and should have said the context, but that's where it ends. This seems so mischievous now. I do not feel any regret wondering if there's other cases, other things that this officer has looked at that should be questioned. Yeah, these emojis, FFS. We need these in this filing. Aaron's gonna look up this case. It is nuts. It is nuts. Good to see you, Amber Dawn. Love y'all right back. No slime left behind. This is crazy. Hey for always, forever for life. YouTube's funny sometimes. Glad you're here. Yeah, Survivor Speaks. This is beyond scary. What do you do? Somebody, like, And it doesn't, let's go back up. So this photo lineup, and again, I didn't see the briefs for this appeal, where I assume there'd be more details here about the photo lineup. But, you know, I don't think there's any way it'd be easy to access the transcripts. There's probably no recording of this trial. But from the limited context here about this photo lineup, where the loss prevention officer, you know, they meet up, they're in a car outside the residence. I'm assuming you didn't bring all that much paperwork if the officer is going over there with stuff they prepared before he went out. So Officer Gallegos, it just says they show him a photo lineup of 6 photographs. And to me, this is signaling a problem, because it's not saying he was shown a series of photographs and when he got to a page with 6 photographs, one of which included Travis Cobb, it to me sounds like they only had one single piece of paper with 6 photographs, 6 possible pictures to choose from, and one of those had the guy. So that means out the gate, if you're asking someone to pick someone randomly and you're only giving them these 6 options, there's a 1 in 6 chance, just with no other factors at play, that a person will randomly select the person you want them to select. A more proper way to do it would be you have several sheets of paper, and maybe you start with one that doesn't include the person you already think it is, and you see if that person says, no, it's none of these 6, it's none of these, and then you move on to the next one. At least, the very least you could have done to make this a little bit more proper and less steering would have been something like that. But it seems like from this limited context, they only showed him 6 photos on one piece of paper and asked him to pick one. And that's not high integrity. That's not a high integrity process. And I would say it goes against standard operating procedures for photo lineups. Goodness. Let's see what else was funky bunch about this. We now know that by the time of the offense, roughly 5 years had passed since applicant's leg injury. Officer Preikshat's information misled others to believe he had seen applicant wearing a leg brace fairly recently to the time of the offense. Medical records contemporaneous to the time of the crime, including previously undisclosed medical records from the Bexar County Jail, show that there was nothing wrong with either of applicant's legs. Officer Preikshat's claim that the applicant was homeless, a detail consistent to what was known about the actual perpetrator at the time, was false. Applicant had been living in an apartment provided by the U.S. Department of Veteran Affairs. So guess what? It sounds like there's verifiable records. And again, the judge isn't spelling this logic out, but including this sentence, the judge expects the inference from any person sitting in the court with him, any of his peers or her peers. We knew the record. There's an official record of a primary residence because the government assigned it to him. So how do we have an agent of the state claiming that he's homeless? Did he even check? What's the conclusion that a reasonable person could draw from that? Did Officer Preikshat even check? He was also regularly visited by a social worker employed by that agency. The social worker confirmed that applicant had no leg injury and had never seen applicant wearing a cast or a brace in any visit leading up to the crime. Additionally, those who knew him attested that he never wore shorts or short-sleeve shirts. This would be me, you guys. I almost always have long sleeves because I don't like the draft. Air conditioning, it's Florida, right? But the air conditioning, the fans are always running. You go outside to go to the store is super cold, restaurant is cold. I live in Florida, but I always have like a coat or sleeves. We also know that the photograph lineup conducted and not for nothing, but a veteran, let me be a little more sensitive. A veteran might be trying to cover like injuries, or it could just be their style, but they might also be trying to cover scars. We also know that the photograph lineup conducted in a car outside Gamez's house was flawed. Oh, we're going to get into it. First, without any explanation as to why, here we go. I am so glad they wrote this 22 pages. It was not presented in a double-blind format as normally required under San Antonio Police Department regulations. So, yes, San Antonio Police Department has these standard operating procedures, and they weren't followed here. And although all parties likely acted in good faith, Gamez clearly stated he identified applicant in the lineup based on his beard and skin color. This was in violation of the instructions which warned witnesses not to base their identification based on changeable features such as head/facial hair and complexion colors. There we go. So, and this is cited to the San Antonio Police Department photo identification instructions. I assume that this might be a instruction that other departments adopt, but I never thought about it before, so that's pretty cool to hear. You know, instruct the person not to base it on these things, but then the person, after they make the identification, explicitly tells you they relied on these two features they're not supposed to rely on. So, never thought about that out loud or read it on paper, so that's interesting. Dr. Trent Terrell, a veteran experimental psychologist specializing in eyewitness memory and identification, also reviewed the photo identification lineup for its reliability. Having been consulted in over 80 criminal cases, he concluded Gamez's positive identification was not reliable for the following reasons. This is great. I love that we get to see this. This is just educational. The witness provided no description of the suspect beyond his age, race, and facial hair. His clothing and description of the leg cast have no bearing on a facial identification. With such limited memory of a person to work with, the reliability of a subsequent photo identification is certainly in question. Latency, stress, weapon focus, and cross-racial identification likely further reduce the reliability of the identification. And we're also dealing with Texas here, right? So I don't go outside that much, but, you know, when I first moved down here, I was outside a lot. I was very tan. If I were to pull up a picture, I'd probably, you know, I couldn't wear the same foundation if I wanted to apply foundation today that I would have been the right color for me when I first lived in Florida for a year, right? And now we're speaking of Texas, so I think it's great to note that cross-racial identification especially likely to reduce the reliability of the identification. The witness identified the suspect based on a changeable feature, facial hair. Had the suspect not been bearded in the mugshot photo, he likely would not have been identified. This strongly calls into question the validity of the identification. The identification procedure was not recorded, despite the officer having the means to do so. This raises questions about how that procedure was carried out. We have no way of knowing how the procedure unfolded or how certain the witness was of his choice. Now, this is an affidavit from 2020, from October of 2020. It seems like this is after the conviction. It looks like maybe they consulted this for the appeals. So, because this is coming from the writ. So it seems like I don't think they had this guy at trial. They didn't have an expert witness called at trial to testify to these issues to the jury. The final and perhaps most important pieces to the puzzle were revealed in the applicant's post-conviction DNA testing of the styrofoam cup that the perpetrator of the attack was recorded drinking from. The test revealed the DNA profiles of two subjects, neither of which were consistent with applicant. The first DNA profile was a CODIS match to Lisa Marie Rojas, who was questioned extensively at the scene of the crime during the original investigation. She was questioned at the time because she was seen entering the Walmart with the suspect and talking with him. At the time of the original investigation, Rojas claimed she had no knowledge of and was unrelated to the perpetrator in any way. The record on post-conviction writ now reveals this was a lie. She was in a dating relationship with Dustin Cody McCall. So that's the guy. We finally have a name. Dustin Cody McCall. At the time of the post-conviction writ, McCall was detained at the Bexar County Jail for unrelated offenses. A DNA sample was collected from McCall under court order. It was matched successfully to the second DNA profile found on the styrofoam cup. Consistent with the DNA profile evidence, McCall's physical appearance attributes are more consistent to the image from the surveillance videos. Moreover, further investigation revealed a witness, and if you ask me, and I appreciate this is this judge playing fact finder, and I love it. He's like, McCall looks more like this guy. So there we go. We have another reason to think it's this guy besides the DNA. Moreover, and it's also saying that if they even thought to just not believe the woman they questioned at face value and looked 2 seconds further into it, the initial investigation could have come to the exact same conclusion that this judge is able to do years later. Moreover, further investigation revealed a witness who knew both Rojas and McCall. During a writ hearing, the witness testified that he heard McCall brag about committing the aggravated robbery in detail and how another person was arrested for it. Based on the new evidence revealed in the writ record, I join the majority of the court in finding applicant actually innocent. I write separately to address the dissenter who challenged, unsolicited, the finding and question whether our standard in Elizondo is rigorous enough to the task of finding someone actually innocent. I keep wanting to read actually as factually, and I guess it's not all that different in like colloquial terms. But yeah. Okay, so Aaron looked up the civil rights lawsuit that Travis Cobb, the wrongfully convicted here, filed against the San Antonio Police Department and the city of San Antonio. It was dismissed and sealed in 2019, but the subject of the lawsuit was related to a violation of prisoners' civil rights. So, a little context there. Guilt shall not escape, nor innocence suffer. So I'm excited to read this because I already know where we're going. I know where we're going. What's the debate, you guys? Is it better for 100 guilty men to go free versus one innocent man to be held, wrongfully held? Let's see where we go. In our criminal justice system, those who serve the state are charged with twofold aim of which is that guilt shall not escape nor innocence suffer. That's Berger v. United States. And they're emphasizing twofold. In the mass majority of cases, these subjects do not conflict with each other because to punish the guilty is to preserve and defend the innocent. But here, what happened with statute of limitations? In criminal cases, our founders established that the government must prove their case beyond a reasonable doubt, lest they condemn an innocent person. We've got a footnote. Our founders adhered to Blackstone's ratio. It is better that 10 guilty persons escape than that one innocent person suffer. From William Blackstone's commentaries to which our founders adhered to when drafting the Constitution. John Adams' argument for the defense, letter from Benjamin Franklin to Benjamin Vaughan. And do you guys see that this footnote is basically telling Judge Yeary that were we here today and in the past, William Blackstone disagrees with you, John Adams disagrees with you, Benjamin Franklin disagrees with you. This is like Yeary, like, bro, nobody agrees with you. Blackstone, whose works we have said constituted the preeminent authority on English law for the founding generation. And that's Justice Scalia writing for the majority. And though this ratio was not intended to be mathematically precise, its wisdom is clear. If and when they conflict, the call to preserve the innocent is more sacred than condemning the guilty. And again, this goes to the question of why is Yeary simping for the state when the state's not asking him to? So, love that there. Oh, we're going to get a Sisyphus reference. I love Sisyphus. So, here we go. And in cases where an innocent person is wrongfully condemned, the great writ of habeas corpus was maintained to right what would otherwise be a travesty of justice. Hence, for those who were truly innocent and wrongfully convicted, our case law in its current form, though not perfect, allows relief from injustice under a Herculean burden standard of proof. And this burden is rightfully intended to be set at a level of difficulty high enough so as to separate out those who frivolously claim innocence, knowing it is false. But it leaves the gate sufficiently ajar to allow the worthy to pass. Thus, the burden is said to be Herculean, but not Sisyphean. Now, Sisyphus is the guy that was like condemned to like walk uphill with the boulder on his shoulders for all eternity. That's Sisyphus, right? You know, no one could ever possibly do that. It would be impossible. So we get a footnote here. In Greek mythology, Sisyphus was assigned a laborious task of futility as punishment for offending Olympus. He was sentenced to roll a giant boulder up a steep hill for all eternity. Or he's rolling it. I don't know why I have the image of it on the shoulders. Whenever he neared the top of the hill, the boulder was cursed to roll all the way back down to the bottom. And then you got to do it again and again and again. The challenge to Elizondo. In Ex parte Elizondo, this court held that for an applicant to be entitled to actual innocence, he must demonstrate by clear and convincing evidence that no rational jury would convict him in light of newly discovered evidence affirmatively proving his innocence when balanced against the entire record. This standard has stood the test of time without serious attack. So Yeary tries to cite himself like 3 times. He makes a new attack in his opinion here. He's done it more than he cited. All of these times he's raised an issue. And here we have Judge Richardson saying, this standard has stood the test of time without serious attack by the state as insufficiently rigorous since its inception at the end of the last century. Nevertheless, in the face of this Herculean standard, the challenging judge takes the position that we must raise the bar of scrutiny to beyond a reasonable doubt for applicants to be found actually innocent. Footnote: this argument seems inconsistent with itself. Under this argument, factual or historical innocence can only exist when all possibility and suspicion of guilt is removed from the equation. But that can only happen if the standard is held at beyond all doubt and not beyond a reasonable doubt. And to balance the system on the trial end, we would need to require that the jury convicts under the same beyond all doubt. This would be completely unworkable. Yeah. Even the certainty underlying DNA profile comparisons, typically expressed as a fraction like 1 in 10 billion, is a non-zero number. Thus, it cannot satisfy Judge Yeary's strict threshold of proof that an applicant manifestly did not commit the offense, because there will always be a non-zero possibility that that applicant is the true culprit. Yep, this is beautifully stated. I tried to rabble on about this earlier. I wasn't articulate. I was just like yelling about non-zero and realm of possibilities. And look how nicely we have this judge laying it out here. So shout out to them. All of this in spite of the fact that our legislative, executive, and judicial branches have not expressed any concerns over the use of that term when it is granted. So nobody's taking issue with the term actually innocent except Yeary. The Texas Supreme Court has adopted the term actual innocence in determining when and if the exoneree should be compensated by the state for years of wrongful incarceration. The legislature passed the Michael Morton Act in honor of a man who was wrongfully convicted and incarcerated for over 20 years. And if Aaron, let's see. So the footnote there was in Ray Allen, 366 SW 3rd 696 706 Texas Criminal Appeals 2012. And the takeaway, it acknowledged that actual innocence habeas relief granted by the Court of Criminal Appeals entitled applicant to compensation from the state under the Timothy Cole Act. And now we have a cite to the Texas Code of Criminal Procedure, Article 3914. This act was prompted by the state's failure to turn over exculpatory evidence that could have exonerated Morton decades earlier from his wrongful incarceration. During his incarceration, his young child grew up being falsely told that his father murdered his mother. Passage of the act was bipartisan and signed by Governor Rick Perry. So again, we have that agreement here. The Texas Tech University campus bears a statue honoring Timothy Cole, a veteran and student at the university who was wrongfully convicted and imprisoned for the 1985 sexual assault of another student. And even though another inmate, a serial rapist, confessed to the crime, Cole's protestations of innocence went ignored. Cole tragically died in prison from an asthma attack that the state's evidence at the time asserted he could not have had. I guess this is coming from the state trying to fight a claim of liability against them for his death. As a result of DNA testing after his death, Cole was posthumously exonerated by Governor Perry, and the Timothy Cole Act was passed into law. So, DNA testing after his death. However, we now find ourselves again engaged in the unsolicited argument of whether one is only innocent, actually innocent, or in some legal purgatory black hole of never having been found guilty of anything. The Texas Code of Criminal Procedure, I love that. I love that. Legal purgatory black hole of never having been found guilty of anything. The Texas Code of Criminal Procedure, Article 3803, and the Texas Penal Code, Chapter 2, Section 201, states that everyone is presumed innocent until proven guilty beyond a reasonable doubt. It's like we have to yell this to Judge Yeary. Even to the die-hard originalist, that language seems patently clear. You are innocent until the state proves you guilty. As a result, it stands to reason if no jury would find you guilty beyond a reasonable doubt, following a successful writ application, one is at least entitled to the presumption of innocence. So the theory is, rather than this legal purgatory black hole, we go back to the presumption of innocence that we had at the start. Moreover, if you are found not guilty in our system, you have the right to have your record expunged, which is as though the arrest and offense never occurred. For most other reversible errors, the applicant only bears the burden to show some type of harm that undermines the confidence of the verdict. If he succeeds, he typically can only earn the relief of a new trial. Granted, there might be cases that prevent one from being found guilty beyond a reasonable doubt, where evidence is excluded or unavailable on unconstitutional grounds. Some of those instances have occurred in the series of Goins cases from Houston. In those rare cases, we have simply granted relief by setting aside those convictions and remanding the case to the trial court for further proceedings. But we have not granted actual innocence. And this is important because he's saying, like, it isn't, again, we saw this in the other opinions, but it isn't just a matter of if we want to grant someone relief, we have to always declare them innocent, and that it's too easy to declare someone innocent. Yeary is the one making an issue out of it. That if we grant someone relief, and if we find a particular individual in a particular case, if we make a finding that they had actual innocence, somehow we're dismantling the entire system that convictions are predicated on to stand and exist, to continue to exist. Like, Yeary just has, like, this irrational fear of no conviction being able to stick. Our standard for actual innocence in Elizondo demands far more. The applicant must offer evidence that, when combined with the existing evidence and viewed in its totality, unquestionably establishes the applicant's innocence. And although each case is evaluated on a case-by-case basis, the applicant must typically undermine each piece of the state's evidence such that no rational jury would convict him. And even then, this court still has the power and does deny relief when it becomes obvious that the relief sought might simply be a new trial. And some people do make their filings. You know, we've talked a lot. We've seen it in these opinions. Meritless, frivolous filings. Yeah, that happens. But there's also a good percentage of writs that come in, petitions that come in, where the relief they're seeking is just a new trial. Let us have a new trial. Rather than let us free forever. Ignore the other evidence because we're raising issue with one piece of evidence. So Yeary's living in, like, a funnel vision world. And I think these judges see it the way I'm starting to see it. It speaks volumes for how difficult the standard is to achieve when there is no known record of a defendant being retried in our system after having been declared actually innocent, even though the state has the right to do so. Both concurring opinions make it sound like some sort of grave injustice is committed if by chance we erroneously declare a person actually innocent. However, they ignore the fact that the state may try that person again, even in light of actual innocence finding by this court. However, there is just no record that it has ever happened. Yeah, so it's just like this funnel vision paranoia. It doesn't match reality. A pattern of concurring and dissenting opinions. Nevertheless, this disagreement is not confined to semantics nor the technicalities of a legal standard. This is because Judge Yeary's concurring/dissenting history suggests nothing more. It suggests that true actual innocence relief, in his view, ought to be effectively unattainable in even the most shamefully wrongful convictions. In each of these cases, the state recommended granting relief by a new trial and or actually innocence. So this is a straight call out to Yeary doing this over and over again, and here you're doing it again. His history, Yeary's history of doing this, isn't just a semantics or clarifying the legal standard. It's his personal gripe. It's Yeary's personal gripe that wrongful convictions get overturned at all. And he's highlighting, this judge, he or she is highlighting, this is a guy, this is Bert Richardson. In each of these cases, the state recommended granting relief by a new trial and or actual innocence. So all of these times that Yeary's sitting here advocating for what he's advocating for, the state isn't even advocating. It's only Yeary. That's crazy. You've got someone sitting on the highest criminal court, the highest level of court in Texas for criminal matters. It's where you would exhaust your petitions for relief at the state level if you were convicted and had an issue with your conviction. There's a judge sitting on here that the other judges are saying just has this ridiculous ongoing issue with someone being able to obtain an actual innocence finding, even though there's a Herculean standard that they need to reach to get there. So, like, it's great to see this call out, but this judge has been sitting on this court for long enough that there is this history at all. And luckily, it's just one. Are we going to go through the patterns of it? Okay, wait, I think we're going back in time to Yeary, because it says Ex parte Casey. Let's see. The pattern of keeping actual innocence relief unattainable begins with Sonia Casey. We're going through the Yeary history, you guys. That's why this is 22 pages. Oh my goodness. For context, you guys, let's look up Bert Richardson, right? Is that his name? I hope I'm not getting his name wrong. Yeah, Bert Richardson. Alright, so this is... Oh, that picture's not loading. Okay, this one loads and it's kind of funny. This picture looks like he's looking at it like, what are we doing here? But this is Bert Richardson. This is who's writing this, and he's going through the history of opinions from his colleague, Yeary. The pattern of keeping actual innocence relief unattainable begins with Sonia Casey. In 1990, Sonia Casey lived with her uncle after her parents tragically died. Her uncle, a heavy smoker, was universally recognized by all members of the family to be extremely reckless with fire and cigarettes. He's citing other findings from in response to a writ. Family members testified that Casey's uncle required the use of an oxygen tank due to health issues. Ooh. So that's a... I'm pretty sure that's an issue because that's a fire hazard, right? Oxygen tanks near flames, you could have a big issue there. He often lit multiple cigarettes after forgetting that he already had others lit. He carelessly dropped cigarettes on the floor. Additionally, Casey's uncle often used a blowtorch to roast hot dogs and marshmallows. I mean, look, I watch a lot of cooking shows, and I've been saying I need to get a blowtorch because I be wanting to put, you know, I don't have like a yard. I live in a condo, so I don't have a yard to like grill food. I'm like, oh, they use these blowtorches to get the effect. Casey's been doing it. Casey's uncle's been doing it big. He's been using the blowtorch method from the comfort of his own home. One morning, the house caught fire and burned down. Casey escaped by crawling out of her window while her uncle died in the blaze. She attempted to go back into the home to rescue him, but was restrained by the firemen at the scene. Casey was accused of murder by arson after a forensic lab analyst tested the remains of her uncle's clothing and found the presence of gasoline. This was the only physical evidence to support the prosecution's theory that Casey poured gasoline on her uncle before setting him on fire. There were no other pour patterns identified in the house, as typically found in other arson cases. The state provided no motive for Casey to kill him or burn down the house. Interesting, we have a footnote, but also a footnote about a parenthetical about the footnote. In fact, after Casey's parents passed away, Casey was homeless and her uncle allowed her to live with him. Thus, Casey did not have any motive to set her residence on fire. So she'd be... This judge loves, like, weighing the cases. This judge, it'd be interesting to revisit, like, what cases he sat over before he was a judge with this court. Casey was found guilty and sentenced to 55 years in prison. However, she received a new sentencing hearing on appeal where her sentence was increased to 99 years. I wonder if Yeary had a problem with this. In 2012, it was revealed that the Texas State Fire Marshal's Office, a separate agency independent of the state, defense, and judge. Okay. Concluded in an independent investigation of Casey's case that there was no evidence of arson. All right, so that's interesting. New developments in arson investigation discovered that the testing methodology for accelerants were yielding false positives. That's kind of crazy, because this seems like a bigger deal than... this doesn't seem like it'd be isolated to this one case. A review of the gas chromatogram evidence generated from Casey's uncle's clothing found no gasoline present. It was also exposed that the forensic lab analyst had omitted the fact that the laboratory was contaminated with accelerant residue that could have resulted in a false positive for gasoline at the time of his testing. In an affidavit, another former analyst and whistleblower for irregularities at that same laboratory attested that a prior test of the uncle's clothing by another analyst yielded no findings of gasoline. Now, I don't know if we're going to get... Maybe we're not going to call out Yeary. Maybe this has nothing to do with Yeary. But this judge here is making a point of why we need to be able to reach a finding of actual innocence because of situations like this. Because there was no evidence of arson or motive, along with many other reasons, the state prosecuting attorney's office and the habeas judge recommended granting Casey relief on actual innocence. So here we have the state and the court in agreement. This court agreed and issued a per curiam opinion finding... We're going to get Yeary. We're going to get Yeary resisting it. Yeary's name is coming up. So the court and the state say, yep, Casey's innocent. Actually innocent. And even though the entirety of the evidence in the state's case had been invalidated, Judge Yeary, in a published side opinion, refused to label Casey as actually innocent because she had not proven that she manifestly did not commit the offense. Holy shit. Because she had not proven that she manifestly did not commit the offense. What the hell? I think Yeary is my least favorite judge. Like, I think we're gonna get another one, guys. More tales of Yeary's opinions. Ex parte Janie. This view that actual innocence relief should be unattainable continued in Cheney. There, a couple known to sell cocaine were found brutally stabbed numerous times and their throats slashed. Bloody shoe prints from 2 sets of shoes, blood smears, and blood spatter were all over the apartment. Additionally, a human bite mark, oh god, we're gonna have bite mark evidence, guys, was found on the male victim's arm. It was universally agreed that the killer would have been covered in blood from the knees to his feet. After what appeared to be a drug ledger connected Cheney to the couple and showed he owed the victims money. There's a footnote. Testimony from the state's star witness later showed that Cheney had cleared his debt to the victims and thus had no motive to kill them. Investigators visited Cheney at his work and saw him wearing tennis shoes consistent with one of the bloody shoe prints at the crime scene. A partial thumbprint belonging to Cheney was also found near the kitchen entrance. Not that weird for someone to be at the kitchen entrance if they're coming to this house to do pickups for drugs. I mean, typically, maybe you only buy once, but you probably be there multiple times. Also, a little bit of a sidebar, there was another exoneration recently announced where the officer, I tweeted it, the officer, star detective of the case, said, was it this one? Edward Wright? Here we go. Do a quick summary of this one here. Speaking of bloody floor tiles, check out this other recent exoneration from April 11th, right? This is why we got to talk about them. All these examples of exonerations are exactly why Yeary's logic cannot fly. So this man, this is Edgar Wright, 40 years he did in custody. On April 11th, 2025, Edward Wright's murder conviction was overturned. This was his 6th motion for a new trial. He was seeking a new trial as his relief. Hampton County Superior Court Judge Jeremy Bucci concluded the prosecution knowingly withheld exculpatory evidence. He also found that a detective gave false testimony about shoe prints found on 2 tiles at the crime scene, key evidence used at the trial. It was the only forensic evidence tying Mr. Wright to the blood on the apartment. Now, the short story on these footprints, there was, it was like a 4 or 5 day period where the murder victim was murdered, and like a 4 or 5 day window where the police on May 17th, they end up identifying, it was like May 14th the murder occurred, May 15th maybe. Then on the 17th, they identify shoe prints on 2 tiles. And on the 18th, they come back and they pick the tiles up and collect the kitchen tiles into evidence, the floor tiles into evidence. But there was a break-in at the house, at the residence, on the 16th or 17th. So after the murder, someone broke into the house to go and rob things from the property. And they don't see these shoe prints until the 17th, and then they collect the tiles on the 18th. And then at trial, they say there were Nike shoe prints, Nike, on these tiles, and Edgar Wright had Nike shoes. So, but the brief summary there of the issue for Edward Wright, speaking of shoe print identification, or not even shoe prints matching a make or model of a shoe. Not a specific pair. The fact that Ingham, this is the officer, wrote the break-in report. So this officer wrote the break-in report. He's the one that responded to the scene of the break-in. The fact that he wrote this break-in report compels the conclusion that he knew when he testified at trial about the break-in and the shoe print evidence was collected after the break-in. Ingham knowingly misled the jury by testifying falsely that, to his knowledge, only police officers had been at the crime scene during the period in which the evidence, including the linoleum floor tiles, were collected. Ingham's false testimony concerned at least the weight and possibly the admissibility of the evidence, so the tiles, central to the prosecution's case, as it was the only forensic evidence tying the defendant to the blood in the apartment. Grant's testimony and opinion linking the defendant to that bloody shoe print evidence were premised upon the assumption, consistent with Ingham's false testimony, that the crime scene evidence had not been contaminated. The court finds that Ingham's blatantly false testimony on this key aspect of the prosecution's case was intentional and was reasonably likely to have affected the jury's judgment. Such false testimony supplies the defendant with a second reason for which he's entitled to the new trial. And then the prosecution had this evidence and didn't turn it over. They didn't turn over this information on timelines and in the report. And in Ingham's report, he referred to the property address. So as he's responding to this break-in that night, the night it happened, he writes in the report that it occurred at the blank's estate. So he's acknowledging contemporaneously that this is the house of someone that was just deceased and is actively subject to an investigation. But yet when he testified at Edgar Wright's trial, he's like, no, nothing happened in between. Yeah, the first time we noticed the tile was the 17th. Nobody else was in that property between the time of the crime and when we collected those tiles, though. So that's a sidebar there, but can't get enough of these stories of shoe print identification and misleading evidence. But if we get back over here to Richardson and his roll through a brief recap of cases of actual innocence where Yeary has had stupid opinions, we get back to the story of Cheney. A partial thumbprint belonging to Cheney was also found near the kitchen entrance. The shoes were tested for blood. Although no blood was visible, the testing resulted in a presumptive positive for the presence of blood on the shoes. 2 odontologists, how do you say that, also compared the bite mark on the victim's arm to Cheney's teeth. So we've got bite mark evidence. Both testified that they are a match. Because the bite mark comparison evidence was the state's only evidence establishing the identity of the perpetrator, the state spent nearly the entire second closing argument explaining how only 1 in a million could have possibly made that bite mark. Although testimony from multiple defense witnesses showed he was somewhere else at the time of the murders, the jury found Cheney guilty based on the strength of the bite mark comparison evidence and sentenced him to life in prison. Now we know where this is going, right? 3 decades later, new developments in the field of odontology revealed that using bite mark comparison evidence was scientifically unreliable in establishing the identity of suspects. And although the thumbprint placed Cheney at the apartment at some point, it was consistent with his past visits to the home. Because these new developments completely undermine the state's identification of Cheney as the perpetrator, and it's important, this is why we're highlighting that they spent their entire second half of their closing on this piece of evidence. It's clearly, in the state's own viewpoint, a key piece of evidence. The case was reinvestigated and the witness re-interviewed. During the second investigation, it was revealed that forensic testing of Cheney's tennis shoes found absolutely no blood on them. Furthermore, during the original investigation, detectives had searched Cheney's residence and clothing only to conclude that there was no blood evidence to be found there. None of this exculpatory evidence was revealed to Cheney's attorneys leading up to and during Cheney's trial. DNA testing was also conducted on the female victim's fingernails to reveal the presence of 3 male contributors, but none of those profiles were originating from Cheney. And consistent with these exculpatory results, Cheney was also excluded as the producer of some hairs found in one of the female victim's hands. In fact, the state characterized its investigation as uncovering a, quote, vast amount of evidence to support Cheney's actual innocence claim. So this is the pattern with Judge Yeary, right? The state's like, oh, yeah, we agree, this person's actually innocent. State's not advocating, no, they're not innocent, we want a retrial, don't overturn their conviction. State's like, oh, wow, yeah, they're actually innocent. This court found that Cheney had managed to invalidate every piece of the state's evidence. Thus, the court concluded that no reasonable juror would have convicted Cheney under the totality of all the new and old evidence. But what does Judge Yeary do? However, Judge Yeary disagreed with the habeas court, the state, and this court's majority. Though he agreed Cheney was entitled to relief under Article 11073, quote, I do not agree that Cheney has even established entitlement to relief under Elizondo, much less that he is actually innocent in any definitive sense. He further claimed that it lies outside our judicial authority to exonerate convicted persons. In the footnote, so they're just citing his concurring opinion, but say to look at, is this going to say they have the right to do it? Yeah, we looked at this already. So the court can do this relief. We looked at the statute earlier in the stream. And if there's a finding of actual innocence, then there can be a pardon. There can be whatever. Jesus. Claiming that Cheney had yet to prove himself, quote, factually, historically, and morally innocent, and Yeary keeps using these 3 descriptors, he accused the majority of lacking humility appropriate to our true station when we declare to the public that an applicant is actually innocent. We're going to get another one. Oh my God, that guy Nick says he's like that alt juror in YSL. Yes, Yeary and 409. Holy moly. Hey to Happily Angry Lawyer in the chat. This is a good one. So this judge is going through a history of his fellow judges' stupid opinions on actual innocence. Yeah, Adventure Aaron says, guys, I'm starting to think Yeary doesn't know what humility means. Yeah, he's like begging for someone to have some humility towards, and that would benefit the state, and the state doesn't even want it. So it's just like, the recipient of the humility doesn't even want it either. Just crazy. So here's another one. And was he doing this in alphabetical order? Hold on, because we had Cheney and now we're on Cook. And Casey. So, wait, how many cases of this are there? Because we're not even out of C. So we have Casey with CA, Cheney, CH, Cook, CO. Is that just a coincidence? Or is Richardson going, boop, 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 boop? We're just going to pick we're going to pick 5 C cases. Oh my gosh. C for crazy. In Ex parte Cook, Judge Yeary would have denied all relief. The same state agency who was found to have engaged in multiple Brady and ethical violations by this court and the U.S. Supreme Court at least conceded that Cook was entitled to have his conviction set aside. So Yeary doesn't even want to set aside the conviction here. Only one judge on this court disagreed with that recommendation. Cook was wrongfully convicted of the capital murder of a young woman in Tyler, Texas, and sentenced to death. After 3 trials, several appellate reversals, including one by the United States Supreme Court, and a 4th prosecution. Jesus. This court found Cook actually innocent after discovering new exculpatory evidence. This evidence included revelations that agents of the state had violated multiple Brady attempts and had lied about a deal made with a jailhouse snitch. That was their star witness in the first trial. Additionally, I have a feeling that this judge, he's griping with Yeary, but I think he's also griping about these same things. The use of jailhouse snitches, bite mark evidence, all these past things. The exact things that lead to not just actual innocence findings, but the trouble, the inconvenience, the hardship, the loss of liberty and freedom that happens on the road to get here. So to me, this judge is I think this judge has a serious issue with these cases getting to him in the first place. And then to hear a colleague, a fellow judge that he shares a bench with, sit there and say, I don't think the standard's high enough. I think it infuriates this guy. So shout out here to Judge Burt. I have a picture up still. Shout out here to our guy, Judge Burt Richardson. So additionally, DNA tests were linked to the alternate suspect after Cook had been on death row for over 20 years. And the state had used that suspect as a key witness multiple times under oath. So the alternate suspect is the key witness. The DNA discovered in the victim's panties the night she was murdered was actually linked to that witness/suspect. Almost 4 years later, and I don't know, I would use the word underwear personally, but that's me. Almost 40 years later, the alternate suspect admitted, with a full grant of immunity, that he had committed perjury multiple times by claiming he had not had sex with the victim for weeks prior to her murder, and had in fact been with the victim the night of the murder. He also admitted after decades of denial that had knowing possession of a book about sexual homicides with graphic pictures of other murder scenes that bore striking similarities with the victim. So how would they be asking him if they didn't already have this book? So this is straying into questions about the investigation in the Cook case and whatever others that this perpetrator was tied to. How are they must have known about, investigators must have found a book. Did they just disregard this book? Did they think the book was actually Cook's or whoever they held accountable for the other murders that this guy actually committed? They have this book and they can't get this guy to admit it. But they still trust him as a key witness on the stand against Cook. But we found this book in your house and you're telling us you don't know anything about it, but we trust you to put you on the stand for someone else. That's ridiculous. In addition to these new revelations, the physical evidence showed that it was practically impossible for Cook to have committed the crime. These revelations were just the tip of the iceberg that are found in this court's 106-page decision granting actual innocence relief. Whew, I bet. And in spite of successfully invalidating almost every piece of evidence against him, including the new exculpatory DNA evidence, the revelation of the prosecutorial conspiracy to fabricate evidence, other previously undisclosed evidence, and the revelation of perjury by multiple material witnesses. Judge Yeary dissented. Judge Yeary still dissented. Wow. I hope they are right, since their judgment wins the day in this court. In all humility, I may be wrong about my assessment of the evidence in this case, but I remain convinced today that, even being put on notice of the false evidence pointed to by Cook, on balance, a rational jury would still have found Cook guilty. Lord forbid a jury of 12 Yearys. That is the only jury that would convict with confidence after all of this, would be a jury of 12 Yearys. This man needs to be barred from jury duty. Stricken with can you imagine? Because jurors have the right to serve on a jury, right? It is as much of a defendant's right to have a fair and impartial jury seated. It is also a right to me as a member of the public, as a citizen, to serve as a juror, right? There has to be a reason for you to take that right away from me if I want to sit on a jury. Most people try to fight to get out of it so you don't hear about it as much. But can you imagine Yeary sitting on a jury, and he wants to stay on the jury, and state and the defense in whatever case are arguing to strike him, and maybe both sides agree to strike him for cause, but Yeary says, no, I want to sit on this jury, and then they have to pull all of these receipts against him to be like, judge, like, this man cannot be an impartial juror. Like, can you imagine what that conversation would look like? Just crazy. And in declaring so, Judge Yeary would not have even offered Cook a new trial. So again, this was a dissenting opinion, not a concurring opinion where he's just saying, look, I agree that we can give him the relief, but I just don't like actual innocence. I don't want to agree with that finding. He didn't even want to give this guy a new trial in light of all of this. We've got perjury by a star witness who actually did the same crimes and was convicted of the same crimes for other victims. Had this book. We've got like evidence that no longer is reliable. We've got Brady violations, and this guy's like, no, I don't even think relief is warranted. That's just insane. So that's crazy. And we stopped. It looks like he's stopping at these C cases. We went through 3 C's, and he said that's enough. And in general, the pattern in other cases continues. Man, shout out to this judge for giving us a little history on Yeary's opinions. Big shout out here. I'm flicking over. I see a ton of green. So let's get some FFS in the chat. He's out here sniping 1, 2, 3, 4, 5. We've got 5 new members. So I better see a lot of FFS in the chat. This is a free opportunity for you to say FFS. Big thank you for all your support here, FFS. And Chloe says, let me grab my gardening shears. Happily Angry Lawyer says, I'm not like other jurists. Like, that seems like what he's trying to prove. But, I mean, I get that people want to be different, but to what end? To what end? To what end? Aaron says, Cook's attorneys believed the alternate suspect ordered the book and sought to introduce it at trial, but the judge ruled it out. Out of court, witness said he had never seen the book. Okay. Interesting. So to me, it just seems like the state took him at his word. And it seems like if the defense only had this evidence and the judge isn't allowing it in, it looks like the state never tried to pursue an origin of the book, who may have purchased it. The kids eating crayons are different too. Yeah. Just humility written in like a purple Crayola. The pattern in other cases and the instant case. Crazy. Sweetie, thanks for becoming a member. Good to see you. I hope you've been doing well. KC Dog, also another familiar face. Good to see you. Says, Kat, I appreciate you bringing to light so many dark cases. Blessings to you and all you do. Thanks for the kind words. Is it popping up on the screen? It's not changing for me. It still says sweetie. I don't know if you guys can see it or if it's just StreamYard being funky to me. Sorry if it was, okay, it works now. Sorry if it was like strobe lighting you guys. A big thank you here to KC, dog. These cases do suck, and I'm sorry I'm laughing through some of them. I promise I'm only ever laughing at the ridiculousness of the how we got here, or sometimes the responses. In this case, the response is from a judge. But typically in situations like this, prosecutors don't necessarily come out and make a statement like, yeah, we're glad with the outcome with this case, which is what we have here for Travis Cobb. A lot of cases where an exoneration happens, a court finds there to be at least enough to warrant a new trial. Maybe they go all the way and make a finding of actual innocence. Some of the statements from prosecutors are dumb and stupid, and I have to laugh at them for my own relief. But happy to bring the light. I think it's important the more we realize these cases are rare, right? Where we get exonerations, wrongfully convictions are overturned, actual innocence. It's rare, it's rare, it's rare. And yet, like, every couple of days there's a new story. And if we put the math together, it's rare, it's rare, it's rare. There's still centuries lost where people were held in prison for sentences that they shouldn't have had, for things they never should have been convicted for. So I think it like really pisses me off stream. I don't laugh as much when I'm reading on my own. Like, I think laughing when I read things out loud, it like clicks how ridiculous certain things sound, but when I'm like reading just my eyes on a piece of paper, it just pisses me off. It's just like pure annoyance and or rage. So good to see you, Casey Dog, and glad that you're out here like paying attention to these issues as well. Chloe Albert's Revenge says this judge would have said constructive guilt. Stop it. Due to his proximity to, quote, guilty people. Yeah, his guilty associates. His guilty associates. Holy moly, constructive guilt. Please do not give anyone ideas. Don't do it. Let's see. Let's see. And Happily Angry Lawyer, do you have any news? Do you have any news? If you say it, I'll say it. Peter Max says, no, all prosecutors are named Love. Oh, gosh. Holy moly. I miss, Always Lying Love is one of my favorite usernames to see pop up in the chat. I think maybe on X, too, they use the same name. But I always love seeing that name. Shout out here, Peter Ortiz has entered the chat. Boom, 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 whatevers. Yeah, okay. So speaking of boom, 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 whatever, I think Yeary, this Judge Yeary, oh, there's bite mark evidence. There was reliability evidence with arson. Witness perjured themselves. State withheld evidence. Boom, 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 whatever. Like, we might need to apply that to Judge Yeary's logic here. I think it applies. So let's see. More than this, we have not been able to find... Oh, gosh. Here we go. More than this, we have not been able to find any case where Judge Yeary agreed that a successful claimant under Elizondo was actually innocent in the rough decade of his sitting on this court. This is an all-the-way call-out. And it says we. We have not been able to find any case. So we just went through 3 C cases in alphabetical order, just from the letter C. And he said, no, you know what, boom, 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 whatever. They went through, they have not been able to find any case. Can you imagine, you've got 7 judges here, and I don't know how many are taking place, but it kind of seems like it's implying the rest, the other 6. We have 2 other concurring opinions, kind of hinting, one more so directly than the other at Yeary. So it seems at least 3 judges here. Can you imagine at least 3 judges directing their clerks, their staff, to go and look through the previous cases of their colleague judge? Look for anything where it shows any morsel or crumb where he's sympathetic to a finding of actual innocence. And these clerks are going through and they don't find any case. And now we're getting this in this opinion today, in this Travis Cobb case, where these judges seem to be over it, especially Judge Shank and Judge Richardson. We haven't been able to find any case where Yeary agreed to come close to a finding of actual innocence in the rough decade that he sat on this bench. Even claimants he agrees deserve relief under Alonzo. Still, nope, not innocent. So they cite a bunch of cases here where he must have agreed for relief. They said, Yeary, if you want to cite yourself in your own opinions, we're going to cite you. Because we've got 1, 2, 3, 4, 5, 6, 7, 8. I think maybe I missed this one. Maybe it was 9. Like 8 or 9 here. We're going to cite you for yourself because you love being cited so much. Furthermore, despite his implied fears to the contrary, it has never happened that we're aware of where a convicted person declared actually innocent was later found to be objectively guilty of the crime from which he was exonerated. If anything, we've only confirmed the opposite. See, for example, Timothy Cole. But perhaps the final damning aspect, does it get worse, of Judge Yeary's proposed heightened standards for actual innocence is in its application to the current applicant's case. So again, this is all the case of Travis Cobb, wrongfully convicted, misidentified by the back of a head in a video surveillance footage and by a non-appropriate, non-double-blind photo lineup identification. And what else? What are we getting here? What is Yeary doing wrong? By all accounts, this is another clear-cut case of actual innocence. First, even the state concedes a mistake was made and that he is actually innocent. Second, the state has evidence showing another individual is actually guilty of committing the crime. Applicant has convincingly proven under every meaning of that phrase. And I think of Super Troopers here, when they're asking them to pull over, and they're like, pull over! And he's like, he's already pulled over, he can't pull over any further. Well, this applicant has convincingly proven to be actually innocent. He can't prove it anymore. There's nothing further he can do to prove his innocence. He's done as much as possible. That he is innocent of this aggravated robbery. And even though he was innocent, he spent 5 years of his life incarcerated by the state. If Judge Yeary's proposed heightened standards cannot be satisfied in such a clear case as this, then the standard he proposes is far more problematic than corrective, in assuring that the guilty do not escape punishment while preserving the innocence. Now, what happened here in this case? We haven't touched on it in these opinions, but the actual perpetrator cannot be charged with this crime because the statute of limitations has run up. So, great point here to call out Yeary. This is problematic to a perspective that promotes ease to justice. Because this mishap, this wrongful conviction, took up so much time that now we can't get the right guy for it. And because it would allow the oppression of innocence in even non-controversial cases. And here we get the quote again, better to condemn 100 innocent people than let one truly guilty person go free. So he's flipping the standard here. And quoting from Philip Short, Pol Pot, Anatomy of a Nightmare. So the opposite of the better to let 10 go free than convict one innocent. He's saying that Yeary subscribes to this philosophy. That it's better to condemn 100 innocent people than let one guilty person go free. And on this channel, I am 100% opposed to this position. And I agree. I have friends with all different perspectives and all different issues. And I understand that there are a lot of people that, until they start thinking about issues in the criminal justice system, they just innately believe that people are in prison because they did the thing that they were accused of doing. People are arrested because they actually did the thing. We wouldn't be here if you didn't actually do it. And I don't push people like that out of my life, because when I was younger, I thought that too. Why would somebody be sentenced to death if they didn't actually do the thing? And then I heard stories like this, and I'm like, oh gosh, we have everything so wrong way too often. So even if someone starts off thinking this way, I'm not going to shoo them away. But if you make it to this court, you are sitting as a judge. on Texas's Court of Criminal Appeals, the highest court you can go to for criminal matters in Texas. And this is still your philosophy? What is wrong with you? Why are you here? How did you get here? What was your campaign like to get elected to this position? How do you get this far in life with a career in the criminal justice system, adjudicating cases, and you hold this philosophy, and your colleagues are calling you out for it? But yeah, adopting it would be heretical to the inherent principles of our constitutional founders. So, and he goes back to his footnote where he said the founding fathers support Blackstone's ratio, the Blackstone ratio of it's better that 10 guilty go free than for one innocent person to suffer. So this philosophy is heretical to what this country's founded on. Whatever flaws our actual innocence case may face, Judge Yeary's answer is no solution at all because it renders the burden impossible and futile in all but name. This is a serious slap. Like, I don't know if, like, judges can sit in an opinion and say, like, he shouldn't be sitting on this bench. I imagine that they probably can't or wouldn't do that. But this is, like, as close to getting there as I would imagine one would get. And it's kind of coming from more than one judge in just this case alone. So Richardson goes on, accomplishing the twofold aim here. The great irony here in this case is that this court does not have to choose between guilt shall not escape nor innocence suffer. This court can do both. Remedy the unjust conviction of an innocent man and seek punishment against the one identified as the true culprit, which today it correctly does. And all parties, including both the prosecutors for the state and the habeas court, agree that the evidence here clearly and convincingly shows that it is righteous to grant relief to the applicant because he is actually innocent. Only the opinions disagreeing with the actual innocence finding from this court, and not those who are actually charged with prosecuting offenders of the law, advocates differently. So again, it's only Yeary simping here because the state, Yeary's simping for the state, and the state isn't even doing this themselves. In conclusion, and we're getting a Jefferson quote, it is more honorable to repair a wrong than to persist in it. It comes with no surprise that our criminal justice system will make mistakes and reach unjust outcomes despite our honest best efforts. After all, we are only human, but our saving grace is in our aspiration to become more perfect. And achieving that relies not only in our successes when justice is done, but also in maintaining a robust ability to recognize and correct our failures to do justice. Making the Elizondo standard substantially more rigorous would undermine that. Is the Elizondo standard perfect? Probably not. Consistent with our Texas Constitution, could it use some refinement in the types of cases previously mentioned in this opinion? Possibly, but those issues are not presented to us in this case. Is raising the bar to make it virtually impossible to obtain a claim of actual innocence, the solution? Nothing in our jurisprudence suggests that such an approach is necessary. It is already a high burden. Herculean. Our Elizondo standard may not be perfect, but here it is perfectly applied to find applicant actually innocent because he is. Do we need the mic drop emojis? That would be the second time I'd put emojis in this opinion. With these concurring thoughts, I join the majority. Whew. So yeah, I mean, I stopped like here. I stopped at this sentence, you guys. This is what made me do this live. When is it proper for judges on this court to be stronger advocates for the state than, well, the state? And man, they torched Yeary. As they should. I agree wholeheartedly with the torching here of their fellow judge here, Yeary. Just crazy. Did we get a Dolly raid? Hey to Dolly crew. We are wrapping up. We were looking at an actual innocence finding by Texas Court of Criminal Appeals and the concurring opinions where the judges were squabbling with each other. Really, all the judges seemed to... think one of the judges, Judge Yeary, just really wants people to be guilty forever. So I did not expect it to be quite what it was. I'm shocked at this guy Yeary. I am enthused and very happy that the judges are calling it out. They must be at their wits' end. I don't know if they've written the same way in the other opinions that they've cited, but this certainly seems like they're done with it. They're just, this is like stop it, Yeary. So, like, just crazy. But shout out to the Dolly crew tuning in. Wait, is Judge Fleischer in Texas? Is he in Bexar County? Can we get someone else? We need to get someone to swap this seat out. Tag team in. Andrew Welch, can a judge be removed from the bench? I don't think over... I'm not sure this would get there. I think it would have to be like actual misconduct. I know there's ways and reasons that a judge can be removed from the bench. I wonder how Texas works on that. But I would imagine probably an uphill battle for just... He has a crappy philosophy, a very crappy one, an abhorrent philosophy. I don't know if that's the mechanism. He was elected. He was elected. He was elected. Peter Ortiz says, what happened to our justice system? And you know what's kind of crazy, Peter, is it seems like Yeary, it seems like going back in time, there may have been more people that were like Yeary. In different parts of the government, right? So the judicial, the executive too a little bit, and the legislative. And here in this case, it seems like the rest of this court is like, no, we completely reject this philosophy that we've hold 100 innocent people just because we don't want to let one guilty person get away with something. You know, it seems like the 6 of the 7 judges here think that that's a despicable philosophy. The state isn't asking for that, so it seems like the prosecutors related to this case, this office, this DA's office, isn't thinking that way. And yet this guy Yeary, who he kind of looks younger, is still just like stuck on it. Where was he? Maybe we can get an age. Yeah, I mean, he just looks like middle age. He doesn't look like an old guy stuck in old ways, you know? So I don't know. He's like rooting his feet down. Just crazy. Yeah, FFS says, let's ask Judge Glanville. Yeah, how easy is it to remove a judge from the bench? Yeah, Chris Harger says it seems Richardson tore Yeary a new one. And Chris, you may have joined midstream. We did look at a shorter opinion from Judge Newell, where Judge Newell, short and sweet as well. Just link that in the chat. But went after Yeary. Went for the jugular there for Yeary. In 4 or 5 pages worth. But that was really something to go through 3 cases, and you know, each of those cases were just like astonishing evidentiary issues at the trial level. And once again, Judge Yeary is just like, boom, 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 whatever. Peter Ortiz, speaking of boom, 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 whatever, off topic, my birthday is 5. That's Cinco de Mayo. Let's party, my treat. So, speaking of Cinco de Mayo, I didn't know that was actually your birthday. So that's going to be super exciting. But 5/5 is the date, the tentative date for the hearing for Martinez Arnold, the forfeiture stuff. So, you know, tacos, we'll get whatever together, watch that, and be celebrating Peter's birthday at the same time. It sounds like the perfect time. I'm assuming that will start early in the day because it's Whitaker. She always starts things at like 9, 10 o'clock. Somebody better get in and get a... Should we bug Kathy Roussan now? Like, can you ask Law and Crime to make sure they have a Rule 22? But I'll check and get an update. You'll see the stream scheduled. If there's going to be cameras in there, we can watch that. If not, we'll just have to look at the updates later in the day when the hearing is over to see what happens. But that'll definitely be fun. I'm excited to see what happens with that, just because I think Ashley Merchant raised really good arguments, and I think the state is just annoying anyway. So to see Whitaker weigh the arguments and issue a decision, I'm just invested in it. I'm invested in it. But we'll definitely celebrate whether or not that hearing happens on that day. We'll do something. It'll be super fun. Very awesome your birthday, Cinco de Mayo. That doesn't surprise me. Sweetie88 says, I forgot. Will you be covering the Menendez brother hearing that is today? I will not, because I have to get back to doing work. That's been a hot mess, though. Like, that's, again, infighting, right, within the district attorney's office. Some of it lingering from, Gascon, who's no longer in office there. But just that's another example of squabbling within an office, this time the attorney's office, the district attorney's office. So I'll probably try to tune in and at least catch what's going on. Is anybody in the chat? Are you guys going to watch that, or do you have a channel in mind that you're going to go watch that live? Because we can help Sweetie find a good home to watch. Let's see. Yeah, Chloe says that new DA has a grudge, let them out already. Yeah, and just think of the money being spent, the resources being spent to continue on with this. That reminds me, there is a different press conference today. Was it for Edward Wright? It might be for Edward Wright. Let me search Edward Wright press conference. Oh, okay, it would have happened already. I don't see a video result for it. But I would have right, there was a press conference today. The New England Innocence Project was holding a press conference. It was at 10:30 this morning Eastern. So, but I don't see a video link or an update on their website yet. I'll share it when I see them update. But they're going to be talking about the case that we went on the sidebar for earlier with the 2 kitchen tiles that were removed. His exoneration came down on April 11th, and they did the press conference today. So I'd love to watch that. Yeah, Brooklyn, do you know where anyone's watching the Menendez brothers? The hearing on that today? To be honest, Justice Serve TV, they usually go live daily. They might be touching on something like that, sweetie. Let me see, maybe they have it in a thumbnail. I don't see it in the thumbnail, but I know they've talked about the happenings in that before. If you don't already follow Justice Serve TV, they cover a bunch of stuff. Love them over there. But it looks like they're also going to be looking at, like, I think Harvey Weinstein jury selection is still underway for the retrial in New York, and then Karen Reed happening, so. Let's see. Okay, Chloe. Shout out to Chloe. Let's get some dog emojis in the chat. Chloe says, kind of makes me want to have a kid named Innocent and make him go clerk for the judge just so he could hear I'm innocent all day. That would be awesome. Like in the I am Groot voice. The I am Groot. But that's a lot of syllables, so I can't really do the I am Groot with that one. That's hilarious, though. Names that trip up when people have to say it. Definitely love that. Big shout out to Chloe. Let's get some dogs in the chat. FFS is also out here sniping. I think we have 5 more sniped memberships here from FFS. So make sure you're saying thank you here. That's super generous. That's like 10 gifted subs here from FFS. You can still use... They're not always applicable, but there are some YSL trial emojis like, I did these crimes and don't do that. And we've got the judge hammer that are very relevant when we're reading things about, like, Judge Yeary. So make sure you take advantage of those. It makes the chat more fun. Other than that, you guys, yeah, Chris Harger's recommendation, the news streams themselves that are set up right outside the courthouse. So that's always reliable. And typically right as it gets close to the time, those news stations will start their stream like 10 minutes before, and it'll just be the microphone. So if you search around like 10 minutes before the conference is supposed to start, that's when the results will come up on YouTube. Yes, Peter Ortiz says, did Steele join Diddy's team? So he filed a motion for pro hoc vice. I don't know that he's been granted admission, but I think the issue of, they might see an issue of alleged misconduct against Brian Steele because Glanville tried to hold him in contempt. But he explained what happened with that situation and how the Georgia Supreme Court found no wrongdoing and reversed it. Flipped it and reversed it. So I don't know why it would be not granted, but technically it hasn't been granted yet that I know of. So he applied, which means Diddy has consented, wants to be able to retain and have Brian Steele there for his case. So, and I think it'll get approved. So, also, holy moly. Oh, we've got a jumping, is it a jumping lemon and a baby lime? Is that a baby lime? Chat, is the green figure a little lime with appendages? That's very cute. We'll need these. Thank you so much, Peter. This is super generous. We will have to use these limes and lemons on Cinco de Mayo to really get the party going. I guess we could do a reading of the Steele application, you guys. We could do a reading. Not today. But if we get together on one of those, what was the other date? What was the other date? 24th? I think the 24th was the date for the state to have their response in to Ashley Merchant for Duke, the civil forfeiture. Maybe that day, whatever day that is that we read the state's response, we can also take a look at the application. So, because I bet there's some nice commentary in there about that issue that the chat will have some reactions to. What am I looking for, FFS? I have mail. Like on X. Wait, it says, have you ever had a dream like this? I'll check it. I don't know if you mean it for the stream because it was sent 3 hours ago. There we go. Yeah, so Brooklyn says, yeah, he writes Judge Glanville on the application. So yeah, we can look at that on a Martinez-Arnold stream there. Also, you guys, big thank you again to Peter Ortiz for Chloe Albert's Revenge. FFS out here with the sniping. Sweetie hanging out with us today. It was great to see Sweetie. And BigBabyJane popped in. Kate Talley had popped in too. For Always Forever for Life, I know you joined. You didn't get the notification, but you found us anyway, so I'm glad that you were here. That guy Nick and Aaron with the commentary. Lamar hopped in here towards the end of the road here, but it was great to have you in here. Everybody that was able to tune in on something that, this is not a high-profile celebrity entertainment style case, but it's a big deal. These things happen. It doesn't matter to me that this stems from an incident at a Walmart over theft. What happened to Travis Cobb is not fair. It's not right. He lost 5 years, I'd say 6 years of his freedom. He was out on bond, but you're fighting to not go back, and you're fighting an uphill battle, making a Herculean effort to prove that you're innocent. So really, I'd round that one up to 6 years there. Just crazy, crazy stuff. And there really aren't clear-cut avenues. Some states still haven't recognized actual innocence as the pathway to file a petition, and have an appeals court review your case and decide, maybe something wrong happened here. Post-conviction relief Once you're granted, we hear Aaron in the chat, so thank you so much, Aaron, for sharing, like, not just your insights and knowledge and looking at these cases as we're talking about them, but your personal work and advocacy in trying to get better compensation for the estates of family members that were wrongfully convicted. All of these, it's still a new frontier. And we talk a lot about Ashley Merchant. I think she's great. I love the work that she does. I think she's so meticulous with the records that she goes and obtains. But Ashley Merchant, she specializes in post-conviction work, right? And we don't really know her for that, for, representing Duke for up to the point where he took a plea in the YSL case. We don't really think of that in terms of the Trump case, because that's not post-conviction space. The things that she's getting the spotlight for aren't even her specialties and her core passion. But a lot of the work that she does is the post-conviction space, and it is a new frontier. It's something that some people have been screaming from the rooftops, advocating for, but the spotlight's not there yet. The awareness isn't there. So when you guys care, it makes a difference. So it's really important. And Aaron says, Missouri is the only state that bars people from filing freestanding claims of actual innocence unless you're sentenced to death. Hate it here. So that's why it's not all states. You guys are the one exception that's making it have an exception at all. So yeah, I hate that too. I'm not there, but I hate that for you guys there. Yes, next time we get together, or maybe second time we get together, Coronas and taco time for Cinco de Mayo and Peter's birthday. Perfect marriage of calendar dates, if you ask me. And I don't know. I think the 24th we'll meet again, you guys. So see you on the next stream. Take care. And do you guys want to go watch Baby Goats? Baby Goats. Let's see, Valhalla. We've got the baby goat cam here. Okay, so I set up the redirect. We'll go over to Baby Goats. That's going to be over with Valhalla awaits. You'll see some familiar faces in that chat. And I would say that the goats will become familiar faces, or familiar butts, because their butts always seem to be facing the camera. And we'll close out. Take care, Nick. Shout out to Tat. Adventure Aaron, one last thing, says a case to watch if y'all are interested in Innocence work. The Missouri Attorney General will be appealing the exoneration of Christopher Dunn. The prosecutor moved to vacate his conviction last year. Holy crap, I saw that there was an appeal for that. Didn't click that was Missouri. So this is the same Attorney General, and it's a similar argument, right? That the pathway for the exoneration isn't there. They did the same thing with Marcellus Williams. They couldn't have done this without holding a hearing, and they didn't hold a hearing, and they don't actually have the authority to do so. It's a similar argument for Dunn, right? That doesn't surprise me now, hearing that the Christopher Dunn, that's the same Attorney General. What is his name? Andrew Bailey. Andrew Bailey. Let's get a face to a name here. Andrew Bailey. And this is something where I think we need, the statute's got to change there. Statute's got to change, because it just seems like too high of a burden. Okay, yep. So Aaron says our only path is for a prosecutor to move to vacate. Chris was declared actually innocent in 2020, but the judge could not grant the relief. Yep. So I'm telling you, like, post-conviction space is just like a crazy, crazy hot mess. Even some of the stuff that's in place to help allow for post-conviction relief when appropriate, it's not clearly defined. So then there's all these gray area issues. And in Missouri, 2 major cases, it seems like, at least, have this moment of elation where we get some relief granted, and then it was successful with Attorney General. He successfully appealed relief that Marcellus Williams had, And then that elation flipped the other way, and same thing might happen for Dunn. So they've got to clean up and clarify these processes. Aaron, thank you so much for always sharing the knowledge. The motion to vacate was granted in July 2024. Bailey kept him incarcerated 10 days after the court ordered his relief, filed as we waited in the parking lot for Chris. Prosecutor dropped the charge. Yeah, so this is another instance where it seems like Bailey, as Attorney General, is at opposite ends of a prosecutor dealing with the case. So, yeah, for Always Forever for Life is not going to Missouri either. No, but we still gotta, I don't want to go there either, but we're still gonna, like, you know, let's celebrate when, you know, if Aaron has a bill that they're pushing, like, let's talk about it, let's promote it. If it's passed, whatever passes that's positive, like, let's shout it out, because if there's somebody out there that will make a decision because they'll feel like the public approves of them, let's make sure we're making it loud and clear that they're getting approval for the things that we want them to be doing. And on the opposite side, disapproval when they're doing things that we don't think that they should be doing. I don't think it necessarily matters if we live in the state. We might not be a direct constituent, but noise on social media. I mean, look at Fulton County. They just got pissed off because of tweets on the internet relating to Viverito. Those tweets weren't from people, their constituents, like the people that live in that area. But they cared. They got up in their feelings about it. So Aaron, thank you so much. Again, if there's ever like a petition we can sign, just send it to me on X. We'll get it to the chat. You guys all take care, though. Thanks for taking part in this conversation and paying attention to past and previous issues. Don't know when we'll get together again, but love you all. You guys all take care and enjoy the baby goats. Bye, guys.